6. The need to reform the national labor relations ACT. Throughout the RST 150 years of its existence, the United States OCLE discouraged collective worker action. When individual employees joined forces with other workers, they were subject to antitrust or criminal conspiracy liability. 1. Courts did not hesitate to enjoin such collective efforts. 2. On those infrequent occasions when judicial edicts failed to prevent concerted employee conduct, elected employers might employ the National Guard, the state militia, or private security forces to put an end to the employees' efforts. 3. When state legislatures attempted to pass laws prescribing yellow dog contracts, which required employees to promise that they would not join unions, or provisions guaranteeing individuals more healthful work environments, pro-business courts invalidated those statutes as impermissible infringements upon the freedom of contract of both employers and employees. 4. When Congress attempted in the Clayton Act of 19,145 to divest federal courts of jurisdiction to issue injunctive orders pertaining to peaceful labor disputes, the Supreme Court narrowly construed that enactment to prevent striking employees from enlisting the sympathetic support of other workers by limiting the statutory exemption to disputants in direct employer-employee relationships. 6. It was not until 1932, when the Norris-LaGuardia Act 7 narrowly deprived federal judges of the authority to enjoin even sympathy action indigenous to labor disputes, that the federal government provided lasting affirmative support for collective worker behavior. In 1933, Congress tried to grant employees organizational rights through the enactment of Section 7A of the National Industrial Recovery Act 8, but the Supreme Court found that act unconstitutional based on the impermissible legislative attempt to regulate intrastate commerce. 9. Congress responded in 1935 by passing the National Labor Relations Act, NLRA 10, which successfully provided private sector personnel with organizational and collective bargaining rights. Congress specifically indicated in Section 1 of the NLRA that denial by employers of the right of employees to organize and the refusal by employers to accept the procedure of collective bargaining lead to strikes and other forms of industrial strife and unrest. 11. Congress further emphasized inequality of bargaining power between employees who do not possess full freedom of association and employers who are organized in the corporate form. 12. Congress sought to alleviate these problems by encouraging the practice and procedure of collective bargaining. 13. The propriety of this theme was acknowledged by the Supreme Court when it sustained the constitutionality of the NLRA. 14. The NLRA has provided significant rights for millions of American workers. Over 33 million employees have voted in the 345,000 representation elections conducted by the Labor Board since 1935.15. The NLRB has processed almost 800,000 unfair labor practice charges and has issued more than 46,000 decisions. 16. During the past 7 years, millions of workers have taken advantage of the NLRA right to influence their wages, hours, and employment conditions through the collective bargaining process. Millions of collective agreements have been negotiated, most without resort to work interruptions. Even though the duty to bargain does not compel either party to agree to any proposal or make any concession, 17 unionized employers and representative labor organizations have achieved innumerable accommodations of their competing interests pertaining to a multitude of topics. During the RST several decades of the NLRA, Labor Board and court decisions judiciously protected the Section 7 right of employees to form, join, and assist labor organizations and to select exclusive bargaining agents. The NLRA covered individuals with tenuous employment relationships who needed collective strength to counterbalance corporate power. Worker participation in management decision-making through the bargaining process was expanded to include most relevant subjects pertaining to the employment relationship. Remedial orders were devised to rectify the EECTS of unfair labor practice violations. As the NLRA became more established, however, employer groups lobbied in favor of amendments designed to curtail employee rights, and court decisions began to erode important statutory protections. The early expansion of statutory rights and protections. NLRA coverage was initially extended to diverse groups of workers. In NLRB v. Hearst Publications, Inc., 18 for example, the Supreme Court upheld the extension of collective bargaining rights to newspaper sellers who would have been considered independent contractors under traditional legal principles. In Packard Motor Car Company v. NLRB, 19 the court sustained the authority of the Labor Board to provide statutory rights for supervisory personnel. In Hearst Publications, the court adopted the economic realities test to determine which individuals really needed organizational strength to counterbalance the economic power possessed by those for whom they worked. Unless the common law tests are to be imported and made exclusively controlling, without regard to the statute's purposes, it cannot be irrelevant that the particular workers in these cases are subject, as a matter of economic fact, to the evils the statute was designed to eradicate and that the remedies it awards are appropriate for preventing them. Interruption of commerce through strikes and unrest may stem as well from labor disputes between some who, for other purposes, are technically independent contractors, and their employers as from disputes between persons who, for those purposes, are employees and their employers. Inequality of bargaining power in controversies over wages, hours and working conditions may as well characterize the status of the one group as of the other. The former, when acting alone, may be as helpless in dealing with an employer as dependent on his daily wage, and as unable to leave the employ and to resist arbitrary and unfair treatment as the latter. In short, when the particular situation of employment combines these characteristics, so that the economic facts of the relation make it more nearly one of employment than of independent business enterprise with respect to the ends sought to be accomplished by the legislation, those characteristics may outweigh technical legal classification for purposes unrelated to the statute's objectives and bring the relation within its protections. 20. The Supreme Court thus concluded that seemingly independent newspaper sellers and lower-level supervisors were entitled to employee status under the NLRA. During the formative years of the NLRA, the Labor Board and the courts promptly denied and enforced basic substantive rights. Employers began to refrain from overt forms of intimidation as the NLRA proscribed coercive threats and discriminatory treatment. Labor organizations quickly used Section 8(a)(2) to challenge management-dominated employee committees, and the Labor Board directed these company unions to be disestablished. 21 The NLRB and the courts developed legal doctrines to protect the unfettered choice of employees who were the targets of union organizing campaigns. The Labor Board determined that even conduct not constituting an unfair labor practice could provide the basis for setting aside election results where the challenged action may have prevented a fair representation. Election. 22 Under the Hollywood Ceramics 23 Doctrine, elections that may have been influenced by pre-election distortions were nulli ed when material misrepresentations of fact emanated from parties in positions to know the correct facts and the opposing party did not have sufficient time to correct the misstatements before the balloting. As the NLRA matured, the NLRB and the courts prohibited more subtle forms of employer restraint on employee collective action. For example, pre-election benefit increases that might induce workers to vote against representation were proscribed, even when there was no evidence that the employer intended to impermissibly influence the election process. 24 Companies were also prohibited from discharging union supporters for alleged misconduct that occurred during organizing campaigns where no unprotected behavior actually occurred. Because the alleged misconduct was inextricably intertwined with the privileged organizing activities, the court believed that those erroneous terminations would have a chilling effect upon other employees who desired to exercise their protected organizing rights. 25. When employers rejected union requests for voluntary recognition based on claims of majority support and then engaged in unfair labor practices designed to dilute the majority support that had been obtained by the organizing unions, remedial bargaining orders were generally issued. 26 The Supreme Court subsequently intimated that where outrageous and pervasive employer unfair labor practices had significantly deterred employee organizing efforts, the NLRB could, in extraordinary circumstances, issue remedial bargaining orders even in the absence of evidence that the organizing labor entities had ever achieved majority support. 27 The court theorized that these labor organizations would have attained majority strength but for the chilling effect of the employer's conduct. The Labor Board issued bargaining orders in favor of minority unions only in cases involving extraordinary circumstances. 28 Because of the need to balance an efficacious deterrent to aggregate employer unfair labor practices against the right of employees to be free from representation by non-majority unions. 29 The Labor Board expanded the definition of protected, concerted activity to include individual conduct that was found to advance the employment interests of other employees. Thus, an individual employee asserting a right contained in a collective contract would automatically be considered to be acting on behalf of the other workers covered by that agreement. 30 In Alleluia Cushion Company, 31 The Labor Board extended this doctrine, ruling that an individual's complaint under a safety and health statute constituted concerted activity even without a bargaining agreement or evidence of co-worker support. In NLRB v. Weingarten, Inc., 32 The Supreme Court sustained the extension of Section 7 protection to employees requesting union representation during employer-initiated investigatory interviews that workers reasonably fear might result in disciplinary action. Whenever individual employees are called in for investigatory interviews that they believe may culminate in discipline, they may lawfully insist that a shop steward be present before any questioning may occur. The Labor Board subsequently extended the right to co-worker assistance at such investigatory interviews to persons employed in non-union settings in Materials Research Corp. 33. Even though Section 10(c) of the NLRA, as amended by the Labor Management Relations Act, LMRA, provides that the Labor Board shall not order the reinstatement of any employee who has been terminated for cause, the NLRB appropriately recognized that this rule should not preclude reinstatement orders in all cases of worker misconduct. When significant employer unfair labor practices provoked acts of unprotected misbehavior by employees protesting the unlawful employer actions, the board balanced the seriousness of the protester misconduct against the seriousness of the employer violations. If the antecedent employer unfair labor practices were far more serious than the unprotected employee responses, the board directed reinstatement. 34. Section 8(d) expressly provided employees who selected an exclusive bargaining agent with the right to negotiate over wages, hours, and other terms and conditions of employment. 35. Although the NLRA does not include a specie definition of mandatory bargaining topics, administrative and judicial decisions recognize the prerogative of representative labor organizations to insist upon discussions pertaining to such fringe benefits as vacations, 36 pension plans, 37 group insurance programs, 38 unpaid sick leave provisions. 39 Other areas determined to be obligatory subjects of bargaining covered employee discounts, 40 safety rules, 41 employee workloads, 42 grievance procedures, 43 layout and recall rights, 44 and certain subcontracting decisions. 45 By the late 1960s, labor organizations expected to negotiate about most topics that had any meaningful impact upon worker interests. 46. The Supreme Court acknowledged the need for representative unions to maintain bargaining unit solidarity during labor disputes in NLRB v. Alice Chalmers Manufacturing Company, 47 by sustaining the right of labor organizations to impose judicially enforceable NES upon members who cross picket lines to work during lawful work stoppages. The Alice Chalmers Court reviewed the legislative history underlying the LMRA amendments to the NLRA and concluded that Congress did not intend the Section 8(b) 1(a) 48 proscription against union restraint and coercion to preclude the enforcement of internal union disciplinary rules against strike-breaking members. Integral to the federal labor policy has been the power in the chosen union to protect against erosion of its status through reasonable discipline of members who violate rules and regulations governing membership. That power is particularly vital when the members engage in strikes. The economic strike against the employer is the ultimate weapon in labor's arsenal for achieving agreement upon its terms, and power to nay or expel strikebreakers is essential if the union is to be an effective bargaining agent. 49. In NLRB v. Boeing Company, 50 the Supreme Court held that the magnitude of the penalties imposed by labor organizations upon members who violate legitimate union rules does not exceed the propriety of such actions under the NLRA. Even though an excessive nay is more coercive than a reasonable assessment, the court believed that Congress did not authorize the labor board to regulate such internal union matters. The NLRB employed similar logic to ND that it did not possess the power under the NLRA to evaluate the fairness of the internal union procedures through which a nay is imposed. 51 By the early 1970s, it was clear that the labor board and the courts would not interfere with the right of labor organizations to impose discipline upon members who violated legitimate union rules. Representative labor organizations were also provided with significant discretion with respect to the expenditure of dues money collected from employees pursuant to lawful union security arrangements. Although the Supreme Court held in Railway Employees Depot v. Hanson 52 and Machinists v. Street 53 that unions provided with exclusive bargaining rights under federal enactments could not constitutionally expend the compelled dues money of objecting bargaining unit members for political or ideological causes, the scope of these holdings was limited. The erosion of NLRA protections. Judicial limitations on union activities. The NLRA was enacted during the depths of the Great Depression. The Supreme Court had recently invalidated the extension of bargaining rights to workers under the National Industrial Recovery Act, but it now acknowledged the need for special legislation to help bring the country out of the Depression. Although the court began to sustain the constitutionality of various enactments that advanced the rights of working people, including the NLRA, it remained a conservative institution that did not believe that rank-and-file employees should be permitted to exert undue influence against their respective employers. In NLRB v. McKay Radio and Telegraph Company, 54 the court decided to limit the primary economic weapon available to employees. Even though the McKay Radio case directly concerned the propriety of an employer's refusal to reinstate along with other returning strikers several individuals who had been particularly active union supporters, the court took the opportunity to address an issue that had not been raised by the parties. Nor was it an unfair labor practice to replace the striking employees with others in an E-org to carry on the business. Although Section 13 provides, nothing in this act shall be construed so as to interfere with or impede or diminish in any way the right to strike, it does not follow that an employer, guilty of no act denounced by the statute, has lost the right to protect and continue his business by supplying places left vacant by strikers. And he is not bound to discharge those hired to LL the places of the strikers, upon the election of the latter to resume their employment, in order to create places for them. 55. The court decided that an employer's need to continue operations during an economic strike outweighed the rather slight impact upon the permanently replaced strikers. This opinion was a devastating infringement on the statutorily protected right to engage in concerted activity and clearly illustrated the court's determination to provide businesses with the leverage they needed to neutralize the strike weapon that Congress had granted to workers. The Supreme Court was not willing, however, to allow employers to use any device to negate the efficacy of a lawful work stoppage. Economic strikers could not be terminated, because they were engaged in protected concerted activity. 56 Even when they were lawfully replaced, economic strikers retained their employee status under the NLRA and enjoyed preferential recall rights as soon as positions for which they were quali-ed became vacant. 57. Nonetheless, in 1959, Congress amended Section 9, c. 3, of the NLRA 58 to provide that permanently replaced economic strikers may only vote in representation elections conducted within 12 months from the date the strike commenced. This statutory change made it easier for a business firm that had broken a work stoppage to decertify the incumbent union 1 year after the strike began, because only the replacement personnel and reinstated strikers, parties not necessarily amenable to unionization, could vote in that election. In the 1963 Erie Resistor case, 59, the Supreme Court held that an employer could not owe striker replacements 20 years of super seniority to use in future years during layoffs to displace reinstated strikers with greater actual seniority. In Giddings and Lewis, Inc. v. NLRB 60, however, the Seventh Circuit completely ignored the Erie Resistor rationale. It decided that an employer that had hired permanent replacements during an economic strike did not violate the NLRA when it promulgated a rule providing that members of the existing workforce would be recalled in the order of their seniority, ahead of more senior, unreinstated strikers. In the event of a layoff. 61, this practice effectively provided replacement personnel with the super seniority that the Erie Resistor Court had found impermissible. In Trans World Airlines, Inc. v. Independent Fed and of Flight Attendants 62, the Supreme Court established a new rule that further undermines worker solidarity during strikes. A closely divided court held that less senior, crossover, employees who either refuse to honor the initial strike call or decide to return to work during the work stoppage may retain the higher positions they obtain while their more senior colleagues remain on strike, even after the labor dispute has been resolved. This decision encourages less senior personnel to work during a strike to obtain an employment advantage over more senior employees who choose to strike, and causes more senior workers to fear that their participation in a lawful work stoppage may jeopardize the job status they previously earned through years of seniority. Congressional restrictions on labor organization strength. Businesses also petitioned Congress for relief from the economic weapons made available to employees under the NLRA. For example, the NLRA had allowed labor organizations to utilize secondary tactics to further worker interests. A union involved in a labor dispute could lawfully picket a supplier or customer of the affected employer even if the supplier or customer was not directly involved in the labor discord, to pressure the affected employer. The LMRA 63 amended the NLRA in 1947 to prohibit most forms of secondary activity. New Section 10164 directed the Labor Board to seek immediate injunctive relief against unions employing secondary tactics to prevent the continuation of the secondary conduct during the pendency of NLRB unfair labor practice proceedings. The LMRA also provided primary and secondary employers that were affected by unlawful secondary boycotts with the right to seek monetary damages in federal court. 65. Congress further expanded the area of proscribed secondary activity in the 1959 Labor Management Reporting and Disclosure Act amendments to the NLRA. 661 provision outlawed peacefully obtained hot cargo agreements in which a secondary employer and a union agree that the employer will not do business with a business firm directly involved in a labor dispute. 67 The 1959 amendments also imposed severe restrictions on peaceful picketing designed to organize employees or to obtain voluntary recognition of a representative labor organization from the employer. 68 Making it more difficult for labor entities to unionize new workers. Narrowing the scope of NLRA coverage. In 1947, businesses induced Congress to amend the NLRA definition of employee to exclude both independent contractors and supervisors. 69 Congress thus rejected the economic realities test formulated in Hearst publications to determine those individuals most in need of NLRA protection. The Supreme Court further narrowed the statutory definition of employee in Allied Chemical and Alkali Workers Local 1 v. Pittsburgh Plate Glass Co. 70 at issue was whether retired individuals continued to enjoy employee status following their retirement to the extent they wished to bargain over their pension rights. The court ruled that these people were not employees within the meaning of the NLRA because they were no longer actively seeking re-employment with their former employer. In Yeshiva University, 71 the Supreme Court substantially reduced the NLRA protection available to white-collar personnel. The court noted that managerial employees who formulate and effectuate management policies by expressing and making operative the decisions of their employer, 72 have historically been excluded from NLRA coverage by labor board decisions due to their close alignment with corporate management. Since the university professors who sought to organize for collective bargaining purposes this definition of managerial employees, despite their lack of control over their wages, hours, and other terms and conditions of employment, they were found ineligible for NLRA coverage. In College of Osteopathic Medicine and Surgery, 73, the Labor Board extended Yeshiva University by NDING that organized college faculty members who obtain meaningful control over academic matters. Through collective bargaining become managerial personnel and thus, ironically, forfeit their negotiation rights under the NLRA. Thwarting organizational tactics. Over the past 2 decades, the Labor Board and the courts have made it easier for corporations to prevent the unionization of their employees. Under the traditional Hollywood Ceramics 74 approach, the NLRB refused to permit employers to use material misrepresentations to adversely affect the manner in which employees voted in representation elections. Following the publication of a limited empirical study that suggested that employee voting was not meaningfully influenced by employer misrepresentations or threats, 75, the Labor Board abandoned the Hollywood Ceramics doctrine. In Shopping Cart Food Market, 76, the NLRB announced that election rules must be based on a view of employees as mature individuals who are capable of recognizing campaign propaganda for what it is and discounting it. 77. As a result, the board no longer evaluates the impact of misleading campaign statements upon worker free choice. It simply assumes that individuals whose employment destiny is substantially controlled by their employer are not influenced by employer campaign recitations suggesting that unionization may cause a loss of business and jobs. 78. The Labor Board recently decided that it will no longer issue bargaining directives in favor of non-majority unions under GISL. Packing. 79. A labor entity seeking such an order must now demonstrate that it actually achieved majority support. An employer that quickly thwarts an incipient organizing campaign through unlawful threats and discharges may thus be able to chill the organizational propensities of the remaining workers succinctly to prevent the campaigning union from attaining majority support. Even though this employer would incur back-pay liability for the unlawful discharges, it would succeed in avoiding the duty to recognize and bargain with a labor union. In its 1984 Myers Industries decision, 80, the Labor Board narrowed the Section 7 protection awarded to individuals who protest adverse employment conditions. The NLRB determined that individuals who question safety conditions or lodge complaints with state or federal regulatory agencies are no longer insulated from retaliatory employer discipline under the NLRA, unless they either act in direct concert with other workers or assert rights co-ed in existing bargaining agreements. Personnel who are not covered by a collective contract or do not associate themselves with other workers are thus unable to challenge resulting discharges under the NLRA. In 1985, the NLRB decided that the right of employees to request representation at investigatory interviews would no longer be available to unorganized employees despite the absence of language in Section 7 restricting the definition of concerted activities to those in which formally organized employees participate. 81. The NLRA protection awarded to individual employees was eroded further in Clear Pine Moldings. 82. The Labor Board discarded the provocation doctrine that had preserved the reinstatement rights of employees who engaged in non-aggregate misconduct in response to serious employer unfair labor practices. Strikers who protest extreme employer unfair labor practices now forfeit their right to reinstatement if they engage in excessive behavior. When the doctrine enunciated in Clear Pine Moldings is combined with the remedial rule established in Gourmet Foods, it becomes clear that immoral employers willing to ignore their legal obligations under the NLRA can significantly disenfranchise employees exercising their protected right to organize. A company can instruct its supervisory personnel to alert it to incipient organizing efforts. It can readily ascertain the names of the primary union organizers and terminate them in a public and humiliating manner. If the employer is fortunate, its openly provocative method of termination may precipitate unprotected responses from those discriminated against, causing them to forfeit their right to reinstatement under Clear Pine Moldings. Such overtly intimidating conduct would discourage further organizing activity by the remaining workers. This would probably prevent the campaigning union from attaining majority support. The Gourmet Foods doctrine would thus preclude issuance of any remedial bargaining order, restricting the issues subject to bargaining. Currently organized employees may no longer influence their employment circumstances to the extent unionized workers could in the past, due to recent labor board and court decisions that have narrowed the scope of mandatory collective bargaining. In First National Maintenance Corp. v. NLRB 83, the Supreme Court held that a company decision to close part of a business does not constitute a mandatory subject for bargaining. The court used language that could potentially preclude employee participation in many other important management decisions affecting terms and conditions of employment. Management must be free from the constraints of the bargaining process to the extent essential for the running of a pro-table business. It also must have some degree of certainty beforehand as to when it may proceed to reach decisions without fear of later evaluations labeling its conduct an unfair labor practice. In view of an employer's need for unencumbered decision-making, bargaining over management decisions that have a substantial impact on the continued availability of employment should be required only if the BEN-AT, for labor management relations and the collective bargaining process, outweighs the burden placed on the conduct of the business. 84. The court now requires collective bargaining of management decisions having a significant impact upon employment security only when it is likely that the representative labor organization will be able to satisfy employer concerns at the bargaining table. In Dubuque Packing Company, 85, the Labor Board held that a business entity is only obligated to bargain about a prospective decision to relocate production from one facility to another when 1. The management decision does not involve a change in the basic operation of the business. 2. The work to be performed at the new location will not differ substantially from that performed at the existing plant. 3. Labor costs are a significant factor with respect to the company's proposed relocation. 4. The representative union may be able to offer concessions that will satisfy the employer's financial concerns. And 5. There are no unusual circumstances that require a prompt corporate decision that would be unduly delayed by collective negotiations. Intrusions into internal union affairs. Recent labor board and court decisions have eroded union disciplinary authority. In NLRB v. Textile Workers Granite State Joint Board, 86, the Supreme Court held that a union could not discipline individuals who had crossed a lawful picket line to return to work during a strike when they had resigned from the labor union prior to their strike-breaking activities. Following this decision, several labor organizations amended their constitutions to restrict the right of members to resign during ongoing labor disputes. In Pattern Makers League of North America v. NLRB, 87, however, the Supreme Court held that the proviso to Section 8, B.1. A, which gives unions the right to prescribe their own rules with respect to the acquisition and retention of membership, 88, did not indicate a congressional intent to permit labor organizations to restrict member resignations. The court further determined that the Section 7 right of an employee to cross a picket line to work during a strike could not be limited by union provisions limiting membership withdrawals. In Ellis v. Brotherhood of Railway, Airline and Steamship Clerks, 89, the Supreme Court held that while unions could expend the dues money received from objecting bargaining unit members to support conventions and social activities, they could not use such resources to organize other groups of workers or to prosecute civil suits that did not directly involve members of the bargaining unit. The court simply ignored the fact that a union's capacity to organize the employees of competitor RMS directly at ECTS, the job security and employment BEN-ATs enjoyed by organized personnel. It also disregarded the fact that test litigation prosecuted on behalf of one bargaining unit may inure to the direct BEN-AT of employees in other units. For example, a victory under the wage and hour laws, the health and safety statutes, or the civil rights acts could establish a precedent that would greatly advance the employment rights of all employees. Leonard v. Ferris Faculty Assen. 90 further restricted the right of labor organizations to use the funds received from objecting bargaining unit members. The court determined that for challenged activities to constitute properly chargeable endeavors, they must 1. Be germane to collective bargaining, 2. Be justly aided by the government's vital interest in labor peace while avoiding free riders who BEN-AT from representational efforts without paying for union services, and 3. Not significantly add to the burdening of free speech inherent in the allowance of a union security agreement. The court disallowed expenditure of compelled dues money for lobbying, electoral, or other political activities. In 1992, President Bush increased the pressure on labor organizations through Executive Order 12,800 that requires federal contractors to post notices apprising employees of their right to object to the impermissible expenditure of their union dues. 91 propose. Department of Labor regulations will require unions to break down the expenditures contained in annual LMRDA reporting forms into distinct categories: contract negotiation and administration, organizing, safety and health, strike activities, political maneuvers, lobbying, promotional efforts, and other. 92 These rules are designed to make it easier for workers to challenge union dues expenditures, and they will create expensive accounting problems for many labor organizations. Necessary labor law reforms. Over the past several decades, business and government antipathy toward unions have combined with demographic, industrial, and global factors to threaten the continued viability of the American labor movement. If this negative trend is not reversed in the near future, labor organizations will become relatively insignificant institutions by the beginning of the 21st century. Union OCs need to modify their organizing techniques to appeal to white-collar employees, women, minorities, and managerial personnel. Labor leaders must also develop techniques that will increase the economic and political strength of their organizations. Union leaders cannot revitalize organized labor without the crucial assistance of Congress, the White House, and the judiciary. Organized labor should use its newfound economic and political power to persuade Congress to amend the NLRA to provide affirmative support for trade unions. The United States must reconfirm the congressional objectives underlying the original Wagner Act if it seriously believes that vital labor organizations constitute an important component of a strong democracy. The amended NLRA should expand the rights of employees, protect employee choice in representation elections, enhance the economic options available to representative unions, broaden the scope of bargaining, and modify the remedial provisions of the NLRA to discourage illegal employer opposition to employee organization. Substantive changes. Statutory coverage. Congress must amend Section 2, 3 of the NLRA 93 which denies the term employee to re-ECT the economic realities characteristic of the post-industrial society America has become. Individuals who perform services for businesses and might constitute independent contractors under archaic legal doctrines should be provided with statutory coverage to re-ECT the true economic relationship between them and the entities for whom they work. Modifying Section 2, 3 to incorporate the Hearst Publications economic realities test would enable individuals who do not fall within the traditional definition of employee, but nevertheless retain little or no control over the terms and conditions of their employment to benefit from the protections of the NLRA. Congress must also amend Section 2 to limit the scope of the supervisory exclusion. The Labor Board presently NDS supervisory status in individuals who possess the authority to influence the terms and conditions of other employees, even when that authority is rarely exercised. 94 The statutory definition should be altered to exclude only those persons who actually make determinations with respect to the employment of other employees and who do so regularly. Lower level supervisors, who exercise such powers infrequently or merely make recommendations to higher management OCLs should not be excluded from NLRA coverage. Their employment interests are more closely aligned with their rank and la colleagues than with corporate managers. 95 And they require collectivization to advance their employment rights. 96. Section 2, 3 should explicitly exclude managerial OCLs, dened to include only those persons who regularly and meaningfully participate in the formulation or effectuation of fundamental labor or personnel policies directly pertaining to wages, hours, or other terms and conditions of employment. Employees who may be able to influence company rules not immediately related to basic employment conditions should not be excluded from NLRA coverage. 97 Because such individuals lack the capacity to decide those issues that would be the subject of collective bargaining, they should have the statutory right to advance their employment interests through organized e-orts. Representation elections. The statutory right of employees to organize is meaningless without the opportunity to participate in fair representation elections. The Labor Board should prohibit tactics by employer or union agents that are likely to infringe employee free choice. Employers should be prohibited from disseminating information that even intimates to employees that if they vote in favor of unionization, they may endanger their job security. Individuals who depend on their employers for their continued economic existence are unlikely to ignore suggestions that their continued employment security is in jeopardy. The NLRB should require that company representations regarding possible adverse ECTS of collectivization be based upon objective factual circumstances and be limited to assessments concerning demonstrably probable consequences beyond the control of the ERM. 98. Intentional misrepresentations should be similarly proscribed. The Midland National Life Insurance Co. 99 doctrine that permits the dissemination of pre-election misrepresentations is based upon the naive premise that employees are not meaningfully influenced by such factors. Employers would not use these techniques if they did not believe they could influence the election outcome. The Labor Board should return to the Hollywood Ceramics 100 approach and refuse to allow representation election outcomes to be determined by the ability of either business or labor entities to distort the truth. If workers are to vote intelligently in representation elections, they must have the opportunity to become familiar with the arguments for and against unionization. Employers presently enjoy a clear advantage in this regard. They may promulgate rules preventing employees from proselytizing during work time, while their supervisors inform employees about the negative aspects of unionization during the same work time. 101 Employers can lawfully address the issue of unionization at captive audience sessions that workers are required to attend, read anti-union statements over intercom systems, post-election propaganda on company bulletin boards, include negative information about unionization in employee pay envelopes, and mail campaign material to worker homes. Labor organizations are generally unable to employ any of these forms of communication to provide employees with a balanced perspective. Proposals that this communication imbalance be reduced by providing union organizers with limited access to company premises during election drives 102 have been countered by understandable employer concerns with theft, sabotage, and drug usage. A less drastic means of lessening the communication advantage enjoyed by employers would be to provide union organizers with access to prominently displayed bulletin boards. Unions should also be permitted to include information in employee pay envelopes and to mail campaign material to worker homes if employers utilize these. Communication channels. When company OCLs give captive audience speeches in person or through public address systems, employees who support the union organizing drive should be provided with the opportunity to respond to the employer's anti-union message. If these channels of communication are available to union supporters, the likelihood of informed voting would increase. Union OCLs should be given the names and addresses of employees in the unit being organized at a reasonably early date. Although unions are currently provided with this information after a labor board election has been directed, 103 the names and addresses of unit personnel should be made available in a more timely manner. This approach would enable organizers to make home visits and to mail campaign literature to worker homes. To ensure that employee privacy would only be compromised during serious organizing drives, the labor board could limit the disclosure of this information to cases in which union agents can demonstrate that they have obtained signed authorization cards from 20 or 30% of the workers in the proposed unit. To increase the probability of fair balloting, the labor board should mandate that elections be held within 2 weeks after representation petitions have been led. NLRB notices could be immediately posted to apprise elected employees of their rights under the NLRA, and regional OCES could swiftly determine voter eligibility. In most cases in which the employer contests the appropriateness of the bargaining unit proposed by the petitioning union, regional directors could decide the possible combinations. And direct immediate elections. The votes of errant employee groups could be segregated until the regional directors resolve the unit questions, and the labor board would then aggregate the votes of the relevant groups and certify the results. Because employers are generally aware of union organizing drives well before any election petition is led from supervisors who inform managers of incipient campaign efforts, company OCLs would have ample time to disseminate their anti-union message before the election. The statutory right of employees to organize for collective bargaining purposes is meaningless if workers lack the economic power to support their negotiating demands. Without some degree of meaningful empowerment, unionized personnel are forced to engage in collective begging, rather than collective bargaining. The Supreme Court decision in NLRB v. McKay Radio and Telegraph Co. .104 severely undermined the statutorily protected right of employees to strike. .105 The McKay Radio permanent replacement doctrine is being employed with greater frequency since President Reagan decided in 1981 to terminate 11,000 air TRAC controllers who illegally struck against the federal government. A recent AFL-CIO study found that approximately 11% of the 243,300 workers who participated in major strikes during 1990 were permanently replaced. .106 Most were forced to seek other employment, and their representative labor organizations ceased to function as viable bargaining agents for the new personnel. The McKay Radio holding ignored two crucial propositions embodied in the NLRA: that the law should protect the individual worker as the weaker party, and that the best protection against individual weakness is collective action. 107 By permitting employers to hire permanent replacements for striking employees, the court effectively destroyed the economic balance that Congress established in the NLRA. The strike weapon. Some commentators argue that struck employers should not be permitted to hire temporary or permanent replacements for striking employees, because the retention of such replacements would impermissibly interfere with the unfettered right of workers to resort to work stoppages. .108 A complete prohibition against the employment of any replacement personnel, however, would unduly prevent companies from protecting themselves against truly excessive union demands. A policy that would balance the interests of both struck employers and striking employees is necessary to resolve these competing issues. For example, the NLRA could be amended to bar the hiring of any replacements during the RST 1, 2, or 3 months of an economic strike. The elected employer could continue to function with regular managerial employees, but could not employ replacement workers during the Speci Ed period. After the designated interval elapsed, the struck ERM would be permitted to employ temporary or permanent replacements. This type of restriction would preclude the displacement of striking employees during the initial period of a job action, but it could create major problems for business entities unable to maintain minimal operations through the use of managerial personnel. A more reasonable alternative would involve the balancing approach frequently utilized to determine the degree to which employers may curtail protected employee rights due to business exigencies. .109 Struck employers could be allowed to continue to operate through the hiring of temporary replacement workers who would be laid off as soon as the striking employees terminated their job actions. In most situations, struck companies desiring to maintain operations would be able to locate a sufficient number of quali-ed temporary replacements to reduce the economic impact of the work stoppages. Struck employers would only be permitted to hire permanent replacements when they could demonstrate by clear and convincing evidence that local labor market conditions preclude the employment of quali-ed temporary workers. To prevent the labor board or courts from permitting the premature hiring of permanent replacements, Congress could enact a statutory provision proscribing the employment of permanent replacements during the RST month or 2 of any work stoppage. A rule preventing or restricting the hiring of permanent replacements would prevent struck businesses from using employee job actions as an excuse to eliminate the jobs of individuals who engage in concerted activity or to decertify incumbent bargaining representatives through the employment of permanent replacement personnel. Such a rule would also deprive RMS countering union organizing campaigns of the ability to caution employees that if their selected bargaining agent calls a work stoppage, workers who participate can be permanently replaced. 110 Disallowing permanent strike replacements would simultaneously prevent crossover employees of the existing bargaining unit, who refuse to strike with their fellow workers or who return to work during an ongoing job action, from retaining the positions they obtained ahead of more senior strikers whom they replaced. A rule prohibiting permanent replacements would enable all of the individuals who engaged in a strike to displace temporary replacements, including crossover personnel, who momentarily occupied their positions. In 1991, bills were introduced in Congress that would have either prohibited the hiring of permanent replacement workers or limited the employment of such persons to circumstances in which temporary replacements could not be retained. Although the House of Representatives voted to adopt H.R. 5, which would have barred the employment of permanent replacements, 111 congressional supporters were unable to overcome business and White House opposition to the proposed legislation. Secondary labor activities. In enacting the NLRA, Congress recognized that workers could only effectively counter the economic power of corporate entities through concerted action. At the present time, employees involved in a labor dispute against an employer are only permitted to direct economic pressure toward that firm. Section 8(b)(4)(b) prohibits workers from inducing employees of secondary business entities to cease handling products going to or coming from the struck company, or from threatening or coercing secondary parties to convince them to cease doing business with the primary company. 112 Employees may engage in consumer picketing at retail stores that request customers not to purchase goods produced by the struck business. 113 So long as the struck goods do not constitute the principal items carried by the secondary retail establishment. 114 They may also distribute handbills asking prospective customers to refrain from patronizing those shops if they continue to carry the struck goods during the labor dispute. 115 But they may not precipitate any cessation of work by the individuals employed by secondary retail establishments. These restrictions on the use of secondary actions by employees in labor disputes severely curtail the economic weapons available to unionized personnel. The NLRA should be amended to permit some forms of secondary activity. Congress must acknowledge the significant imbalance in bargaining power that has developed over the past 2 decades as a result of industrial and technological changes that have diminished the efficacy of conventional work stoppages and the ability of struck business enterprises to hire temporary and permanent replacements. Congress must also recognize that a strike at one firm generally has an impact on other unrelated entities. A successful work stoppage shuts down the operations of the target company. As a result, the business may be forced to suspend its purchases of raw materials and to reduce its shipment of niched goods. When striking employees are unable to generate a complete cessation of primary operations through a strike, they should be able to expand their concerted activities to reach secondary companies that deal directly with the struck employer as suppliers or customers. Workers engaged in a work stoppage should be able to induce the employees of secondary RMS to refuse to handle the raw materials destined for the struck firm or the niched goods coming from that establishment during the controversy. If an employer attempts to limit primary employee picketing of suppliers or customers by creating an RDCL middle enterprise through which it funnels raw materials or niched goods, the RMS dealing directly with that enterprise should be susceptible to primary employee picketing. Congress should also amend Section 8(e)(116) of the NLRA to permit primary employees and their union to ask secondary parties having direct relationships with the primary employer to enter into agreements in which they promise to cease doing business with the primary company during lawful work stoppages. Congress should amend Section 8(b)(4)(b) to permit striking individuals to appeal to customers of secondary retail stores. If a struck firm is unable to produce during an industrial dispute, retail stores are unable to obtain the products normally manufactured by that company. Strikers should be able to use placards or handbills to induce prospective customers to cease shopping at retail stores that continue to carry the products of the struck firm during the existing labor controversy. No distinction should be drawn between peaceful consumer picketing and peaceful consumer handbilling. Nor should the amount of revenue derived from sales of the struck goods etc. The legality of such consumer appeals, since a complete shutdown of the struck company would force the retail establishment to explore the availability of products from alternative RMS regardless of the protests lost due to the unavailability of the goods at issue. If the secondary retail store is a direct customer of the primary employer, the striking employees should be permitted to ask the retail workers to cease handling the primary party's goods. If there is no immediate relationship between the two entities, the consumer picketing and handbilling would lose its statutory protection if the participants cause secondary retail employees to stop work. Were corporate leaders concerned about production losses caused by more effective work stoppages, they could support other innovative alternatives. For example, An NLRA amendment could prohibit economic strikes, but mandate the resolution of collective bargaining impasses through binding interest arbitration procedures. Tripartite arbitral panels could be empowered to select the more reasonable NLRA made by the employer or the union, either on an issue-by-issue or a total package basis. Various state public sector bargaining laws have successfully employed interest arbitration procedures as a substitute for proscribed strike activity. 117. Employers could alternatively support an amendment to the NLRA that would permit only statutory strikes that would not involve actual work stoppages. 118. After a bargaining impasse was reached, the employer or the labor organization could declare a strike. Production and services would continue as usual, but employee wages would be reduced by a specie amount, e.g., 25%, and company revenues would be reduced by the same percentage. If the parties resolved their dispute promptly, the withheld compensation and revenues would be returned to the workers and the ERM. If the controversy were not settled quickly, however, the withheld funds would be permanently transferred to the public treasury. The financial incentives associated with statutory strikes would encourage labor and management representatives to resolve their bargaining impasses expeditiously without disrupting production or depriving workers of their livelihood. Protections for non-union personnel under the NLRA. Individuals who question safety conditions or lodge complaints with state or federal regulatory agencies are not insulated from retaliatory employer discipline under the NLRA unless they either act in direct concert with other workers or assert rights. Code ed in existing bargaining agreements. 119. Congress should amend the NLRA to clearly provide that unorganized individuals who raise issues of obvious interest to other employees with their employer or with regulatory bodies shall be considered engaged in constructive concerted activity and be entitled to protection under Section 7.120. The distinction between union and non-union personnel established by the Labor Board in Sears, Roebuck and Company, 121 with respect to employees who request the assistance of fellow employees during investigative interviews they reasonably fear may result in discipline, has no foundation in the language of Section 7. Congress should amend that provision to indicate that both organized and unorganized employees have the right to ask for the support of other persons during such investigatory interviews. The scope of bargaining. The Supreme Court and the Labor Board have unduly restricted the scope of bargaining available to representative labor organizations. The NLRA was designed to enable represented personnel to deprive corporate OCs of their ability to make unilateral determinations with respect to issues of direct relevance to bargaining unit members. 122. Congress should amend Section 8d. 123 to make it clear that designated bargaining agents possess the statutory prerogative to expect negotiations over all company decisions that will meaningfully impact employee wages, hours, and other terms and conditions of employment. Proposed decisions pertaining to such topics as subcontracting, production transfers, partial closures, and the introduction of new technology should all be subject to mandatory bargaining. The inconvenience of such negotiations to employers is irrelevant, because the relatively slight infringement of managerial authority associated with mandatory bargaining is outweighed by the need for unionized employees to participate in the decision-making process that bears directly on their continued economic well-being. This expanded scope of bargaining would not enable labor organizations to prevent management decisions that simply displease bargaining unit personnel, but would merely obligate employers to notify representative unions of proposed changes and provide them with the opportunity to discuss the pertinent issues. Businesses would not be required to make any concessions or to agree to any proposals. 124. Management would be free to implement the position rejected by union leaders at the bargaining table, if employee representatives refused to accommodate employer needs and a good faith impasse were reached. 125. The ability of representative labor organizations to obtain BNACL contract terms is directly related to their capacity to preserve bargaining unit solidarity. Congress should recognize that labor organizations are democratic institutions and that while members may oppose proposed concerted activity, they should not be able to ignore the affirmative vote of a majority of their fellow members. Unions should be permitted to impose reasonable restrictions upon the right of members to resign during ongoing job actions, to preserve the concerted strength of those organizations. Congress can achieve this end by amending the proviso to Section 8b. 1a. 126 to provide that member resignations would not take EECT until 30 days after their submission to the union. Such a rule would preserve the worker solidarity that is essential during the early stages of economic strikes, and would reasonably allow dissenters to escape the disciplinary authority of their labor entities after 30 days. Labor organization solidarity has been similarly undermined by Supreme Court decisions restricting the right of such entities to expend dues money received from non-member employees covered by lawful union security agreements. Even though private sector labor organizations derive their representational status from the NLRA, they are not governmental entities. The NLRA should thus be amended to permit unions to expend dues money for non-political and non-ideological purposes that advance worker rights, such as union organizing, litigation not related to the immediate bargaining unit, or lobbying efforts, even if these purposes do not immediately concern the negotiation and administration of the collective contract covering the instant unit of employees. Representative unions should certainly be able to use the dues money received from objecting members to organize new groups of workers. The job security, compensation levels, and employment terms enjoyed by unionized personnel are directly threatened by the ability of unorganized companies to obtain a competitive advantage through the availability of reduced labor costs. To the extent labor organizations are able to organize most or all members of an industry, they greatly protect the job security and working conditions provided to employees covered by collective contracts. Litigation involving external bargaining units may similarly inure to the benefit of individuals in the immediate unit. Test cases involving wage and hour laws, health and safety regulations, civil rights statutes, and other employment-related enactments generate judicial precedents that will assist all workers. This indirect benefit makes it appropriate to permit representative labor unions to expend dues money received from one bargaining unit to nance. Litigation involving the employment rights of other groups of workers. In most, if not all, such cases, the labor union would merely attempt to obtain through litigation benefits and protections it would otherwise have to achieve through the collective bargaining process. Unions should also be allowed to spend dues money to support lobbying efforts designed to advance the employment rights of all workers. While it would be improper under the First Amendment to permit labor entities to expend the dues money of objecting employees to nance political parties or particular candidates, or to proselytize for or against such ideological issues as abortion or aid to parochial schools, unions should be able to utilize dues revenues to support lobbying intended to enhance the employment interests of all workers. Efforts to increase the minimum wage, to improve health and safety protections, to extend unemployment compensation coverage, to proscribe discrimination, or to protect employees displaced by new technology or job relocations are germane to collective bargaining. To the extent labor organizations can obtain legislation to cover these employment-related topics, representative unions will be able to focus on the advancement of other worker objectives through the bargaining process. Remedial changes. The need for more balanced NLRA remedies. The remedial scheme of the NLRA favors employers. The primary reason for this statutory imbalance is that the most potent unfair labor practice remedies were added to the NLRA in 1947 by an extremely pro-business Congress. Most of the new remedial provisions added by the LMRA pertain to violations committed by labor organizations, not employers. For example, the new Section 101-127 Specie Ed that charges involving secondary union activity under Section 8b, 4, or 8e, or regarding organizational or recognitional picketing under Section 8b, 7, shall be handled on a priority basis. Whenever a charge alleging a violation of one of those provisions is led, the Labor Board is directed to seek an immediate injunctive order against the offending union, to protect the employer's interests while the subsequent unfair labor practice proceedings are conducted. If the NLRB fails to seek a restraining order against the proscribed union activity, the affected business firm may petition a district court for a writ of mandate ordering the board to do so. 128. Section 303 of the LMRA 129 provided employers with additional protection against secondary conduct by authorizing federal courts to award damages to parties injured by Section 8b, 4, violations. Employers that commit unfair labor practices are not subject to mandatory injunctive orders. If a union less a charge alleging a violation of Section 8a by a business entity and the NLRB decides to issue a complaint, the board may seek a preliminary injunction against the offending conduct under Section 10j. 130. The board is not statutorily obligated, however, to seek injunctive relief, and if the NLRB declines to pursue an injunction, the adversely affected employees or labor organization cannot compel that agency to do so. The Labor Board rarely seeks injunctive relief against employer unfair labor practices under Section 10j. The number of employer unfair labor practices has increased dramatically over the past 10 to 15 years. 131. It has become relatively common for companies counteracting union organizing drives to discharge the employees leading the collectivization efforts. If RMS terminates such individuals publicly and flagrantly, they may be able to provoke an unprotected response from the red employees and avoid the obligation to reinstate them. 132. Thus dampening union support among the remaining workers. If the labor entity is thus prevented from attaining majority status, the company does not have to worry about any remedial bargaining order, no matter how outrageous its violations. 133. Corporations that ignore the rights of their employees under the NLRA are generally motivated by the fact that the relatively minimal costs associated with unfair labor practice liability are outweighed by the overall costs associated with worker unionization. These corporations ignore the moral and systemic ramifications of their unlawful conduct, and take advantage of the fact that Labor Board remedies with respect to discriminatory terminations are wholly inadequate. The sole monetary remedy available to unlawfully discharged employees is a board order requiring the offending party to make whole those who have been discriminated against for the compensation they have lost. Unlawfully read individuals are even required to seek interim employment to mitigate their economic losses during the pendency of the NLRB proceedings. 134 Furthermore, labor board reinstatement orders are not particularly effective. Only about 40% of those discriminated against actually accept orders of reemployment, and, of those who do, approximately 80% leave their employer within 2 years. 135. Companies that commit serious unfair labor practices during organizing drives may indeed themselves encumbered by remedial bargaining orders if the adversely affected labor organizations can demonstrate that they obtained majority support from the workers despite the employer violations. Even these remedial directives are often ineffectual. Only about 35 to 40% of unions that obtain remedial bargaining orders ever achieve collective contracts. 136 The more vigorously employers oppose such remedial orders through judicial appeals, the less likely the chance that the labor union will be able to achieve an initial bargaining agreement. 137. Even when companies do not employ coercive tactics and unions successfully obtain labor board certification, fruitful negotiations do not always result. Recalcitrant employers can simply refuse to accede to worker demands. A good faith bargaining impasse is unactionable under the NLRA. Even if employers refuse to agree to union demands in bad faith, the most they need fear from the NLRB is a cease and desist order that will take several years for the petitioning labor organization to obtain and have judicially enforced. 138 By the time meaningful relief is provided, crucial organizing momentum is lost and union effectiveness is irretrievably diluted. If the proliferating negation of NLRA rights by business entities is to be reversed, Congress must provide more efficacious remedies. To deter the crippling impact of Section 8(a)(3) discharges, Congress should adopt a liquidated damages provision similar to Section 16(b) of the Fair Labor Standards Act 139 that authorizes double back pay awards to employees whose rights have been violated. If the Labor Board were empowered to award double or triple back pay to individuals terminated unlawfully during organizing campaigns, this would increase the cost of employer noncompliance. To minimize the loss of organizing momentum associated with the illegal termination of key union supporters, Congress should amend Section 10(1) to make mandatory injunctions applicable to Section 8(a)(3) discharges that occur during organizing campaigns. As soon as a meritorious charge is led, the NLRB should be statutorily obligated to seek an immediate injunctive order directing the offending employer to reinstate the adversely affected individuals. If such persons were promptly returned to their former positions, the negative impact of the employer's violations would be minimized. Congress should amend the NLRA to authorize the Labor Board to issue remedial bargaining orders in favor of labor organizations that were unlawfully prevented from obtaining majority support because of extreme employer unfair labor practices. To avoid imposing an exclusive bargaining agent on employees who do not desire such representation, remedial bargaining orders should only be employed in extraordinary situations. Nonetheless, when the Board is satisfied that majority status would almost certainly have been achieved in the absence of the company's egregious violations of the NLRA, it should be empowered to protect the rights of the discouraged union supporters through the issuance of a bargaining directive. 140. When employers indefensibly refuse to bargain in good faith with newly certified unions or labor organizations that will clearly become the recipients of remedial bargaining orders precipitated by vagrant company unfair labor practices, the Labor Board should be similarly directed under Section 10(1) to seek preliminary injunctive orders. These would force the recalcitrant business RMS to bargain with the designated labor organizations during the unfair labor practice proceedings. Business enterprises would thus be denied the opportunity to disregard the collective rights of their employees during the several years it takes under current law to obtain a judicially enforced labor board order. When employers unjustly ably refuse to bargain, make-whole relief should be available to place the unlawfully disenfranchised workers in the economic position they would have attained in the absence of the company's outrageous disregard for their NLRA rights. Because the NLRB has decided that it lacks the statutory authority to provide such relief, 141 Congress should amend Section 10(c) of the NLRA 142 to empower the board to require compensatory relief. Petitioning labor organizations could present Bureau of Labor Statistics data to support their requests for make-whole compensation, limiting labor board deferral to arbitral procedures. Although the NLRB is empowered in Section 10(a) of the NLRA 143 to resolve unfair labor practice disputes, and that provision states that its power in this regard shall not be acted by any other means of adjustment or prevention that has been or may be established by agreement, law, or otherwise, the Labor Board has increasingly declined to perform this function. In Spielberg Manufacturing, 144 the Labor Board decided that in unfair labor practice cases it would defer to previously issued arbitral determinations that involved the same factual circumstances and effectively resolved the issues raised in the unfair labor practice case. The NLRB would accept the prior arbitral results where the proceedings were fair and regular, all parties had agreed to be bound, and the decision of the arbitration panel was not clearly repugnant to the purposes and policies of the NLRA. 145 The party that sought NLRB deferral to a prior arbitral decision was obliged to demonstrate that the Spielberg prerequisites were satis ed. The Spielberg deferral policy was significantly expanded in Olin Corp. 146, wherein the Labor Board enunciated new standards to be applied when deciding whether to accept a previous arbitral determination in a current unfair labor practice proceeding. We would ND that an arbitrator has adequately considered the unfair labor practice if 1. The contractual issue is factually parallel to the unfair labor practice issue, and 2. The arbitrator was presented generally with the facts relevant to resolving the unfair labor practice. With regard to the inquiry into the clearly repugnant standard, we would not require an arbitrator's award to be totally consistent with board precedent. Unless the award is palpably wrong, i.e., unless the arbitrator's decision is not susceptible to an interpretation consistent with the Act, we will defer. Finally, we would require that the party seeking to have the board reject deferral and consider the merits of a given case show that the above standards for deferral have not been met. Thus, the party seeking to have the board ignore the determination of an arbitrator has the burden of affirmatively demonstrating the defects in the arbitral process or award. 147. The Olin formulation makes it exceedingly difficult for parties to challenge prior arbitration decisions that are not entirely compatible with NLRA policies. The burden of proof has been inexplicably transferred from the party seeking acceptance of the previous arbitral ND-ings to the party opposing such acceptance. So long as the arbitral determination was not palpably wrong, it is entitled to NLRBAR-mation. In addition, courts reviewing arbitral decisions are obligated to enforce such awards so long as they draw their essence from the bargaining agreement and are not clearly repugnant to law or public policy. 148 Such judicial deference is far greater than that accorded to the review of Labor Board unfair labor practice determinations. 149 The expansive Labor Board deference to arbitral decisions has caused the development of inconsistent legal principles that do not provide individual employees with protection as broad as that envisioned by Congress when it enacted the NLRA. Spielberg deferral is appropriate where purely factual issues are in dispute, because it reasonably enhances the federal labor policy favoring the private resolution of labor controversies. 150 and prevents unnecessarily duplicative litigation. To ensure that the prior arbitral proceedings were truly fair and regular, and that the award is not repugnant to the purposes and policies of the NLRA, however, deferral should only be employed where the party seeking deferral can demonstrate that the traditional Spielberg prerequisites have been satis ed. Congress should amend Section 10A to codify the original Spielberg standards and to reject the overly expansive Olin Corp. approach, making it clear that the Labor Board should not accept a prior arbitral award if there is any reason to believe that the Spielberg criteria have not been completely met. The NLRB frequently refuses to consider unfair labor practice claims where no previous arbitral determinations have been issued, if the charges raise issues that might be resolved through available contractual grievance arbitration procedures. Under the Collier, Insulated Wire 151 doctrine, if the respondent is willing to have the controversy submitted to the arbitral process, the board usually withholds its statutory authority and directs the parties to utilize the means of adjudication. In General American Transportation, Corp. 152 the NLRB appropriately acknowledged that such a pre-unfair labor practice hearing deferral is proper where Section 8A, 5, or 8B, 3, refusal to bargain charges are involved. In these cases, the rights of the representative labor organization as an institution are to be determined, and the resolution of the underlying contractual question, which will simultaneously dispose of the unfair labor practice issue, will be made in the forum that the parties specifically established to hear such controversies. Where individual rights are raised under provisions such as Section 8A, 1, 8A, 3, 8B, 1A, or 8B, 2, however, the interests of the aggrieved employee may not coincide with those of either the employer or the representative union which control the arbitral process. Application of the Collier deferral policy to such cases effectively deprives allegedly coerced individuals of access to the administrative agency that Congress created to resolve unfair labor practice cases. Congress should amend Section 10A to codify the General American Transportation approach and limit pre-arbitration deferral to cases involving refusal to bargain allegations. Such an amendment would guarantee individual employees the right to have their claims presented by independent labor board attorneys before the tribunal that possesses substantial NLRA expertise and whose members have not been selected by the employer and the labor organization involved. Epilogue. Over the past 2 centuries, the American labor movement has demonstrated remarkable resiliency. Throughout the late 18th and 19th centuries, craft guilds flourished despite the absence of legislative support. During the second half of the 19th century, social and political institutions like the National Labor Union and the Knights of Labor advanced the employment rights of all workers. After those groups declined, the American Federation of Labor created the business union movement. Although AFL-ALEATs encountered vehement employer and judicial opposition, they were able to organize millions of skilled craft personnel. Once the federal government established the statutory right of workers to organize for collective bargaining purposes in the NLRA, union membership expanded rapidly. The creation of the industrial union movement through the formation of the Congress of Industrial Organizations in the late 1930s led to the organization of mass production industries. Competition between AFL and CIO-ALEATs generated significant union growth throughout the 1940s and 1950s. By the time of the AFL-CIO merger in the mid-1950s, unions represented approximately 35% of the non-agricultural labor force. Even though the private sector union participation rate has declined over the past 3 decades, public sector labor organizations have convinced 35% of government personnel that they will benefit from collectivization. As the American labor movement continues to lose membership and conservative presidents appoint more pro-business judges, the likelihood of a private sector union renaissance seems remote. Nonetheless, there is reason for hope. Changing demographics will provide creative union organizers with new sources for membership. In addition, more and more white-collar and professional employees are becoming disenchanted with their routine job tasks, their diminished employment security, and the increasingly rigid hierarchical structures of their corporate employers. If the dissatisfaction of such individuals continues to grow, many will contemplate the possible benefits of unionization. Labor leaders must devise innovative organizing techniques and develop insightful collective bargaining objectives that will appeal to such people. Even if labor leaders do not make the changes necessary to precipitate increased worker interest in unions, over-content management OCLs will probably do so. As American executives decide that labor organizations are moribund entities that will become insignificant factors by the end of the current decade, many will fail to heed Lord Acton's admonition that power tends to corrupt and absolute power corrupts absolutely. Managers will ignore industrial history and themselves create the circumstances that originally precipitated concerted worker action by abusing their unilateral authority to the detriment of subordinate employees. They will recreate the environments most indigenous to union growth. Their workers will rediscover the reason collective strength is required to counter the excessive economic power possessed by corporate RMS. Public opinion surveys demonstrate that most American workers continue to believe that employment interests can be advanced through unionization, and numerous non-union personnel have indicated that they would be inclined to collectivize under appropriate circumstances. Despite the disadvantageous industrial and global trends, there continues to be a need for worker representation. If American labor organizations can offer dissatisfied employees representational services that will enhance their employment situations and their personal dignity, they should be able to generate sustained union growth. Notes 1. Overview 1. John Galbraith, The New Industrial State, Boston, Houghton. M.I. 1971, 275. 2. Jeremy Rifkin and Randy Barber, The North Will Rise Again, Boston, Beacon Press, 1978, 26. 3. BNA, Daily Labor Report 172, September 5, 1991, A3. 4. Pub. L. Number 93-406, 88 Stat. 829, 1974, Orissa. 5. BNA, Daily Labor Report 165, August 26, 1991, A2. 6. Michael Gold Eld, The Decline of Organized Labor in the United States, Chicago, University of Chicago Press, 1987, 10 Table 1. 7. BNA, Daily Labor Report 28, February 11, 1992, BL. 8. Michael Gold Eld, The Decline of Organized Labor in the United States, 90. 9. BNA, Daily Labor Report 46, March 9, 1992, A10. 10. BNA, Daily Labor Report 241, December 18, 1989, AL. 11. Thomas Edsall, The New Politics of Inequality, New York. W. W. Norton, 1984, 173. 12. Labor organizations indirectly ECT working conditions in non-union shops because many employers provide benefits and working conditions comparable to those of organized business entities in an E-org to prevent unionization by their own employees. 13. Paul Jacobs, Old Before Its Time, Collective Bargaining at 28, Santa Barbara, Calif. Center for the Study of Democratic Institutions, 1963, 14. Albert Rees, The Economics of Trade Unions, Chicago, University of Chicago Press, 1977, 190. 14. See generally Thomas Gagan, Which Side Are You On? New York. Farrar, Straus and Giroux, 1991. 15. Interview with George Meany in U.S. News and World Report, February 21, 1972, 28. 16. Howard Fullerton, The 1995 Labor Force, A First Look. Monthly Labor Review 103, December 1980, 11. 17. James Jordan, Trends in the Workforce, Individualism, Innovation and Productivity, Working in the 21st Century, c. Stuart Shepard and Donald Carroll eds. New York, John Wiley and Sons, 1980, 71. 18. Sanford Cohen, Labor in the United States, Columbus, Ohio. Merrill Publishing, 5th ed., 1979, 97. 19. Charles Heckscher, The New Unionism, Employee Involvement in the Changing Corporation, New York. Basic Books, 1988, 60-61. Gil Green, What's Happening to Labor, New York, International. Publishers, 1976, 92. 20. Paul Weiler, Milestone or Millstone, The Wagner Act at 50. Arbitration 1985. Law and Practice, Walter Gershenfeld ed. Washington, D.C. Bureau of National Affairs, 1986, 40. 21. Ibid. 43. 22. AFL-CIO Committee on the Evolution of Work, The Changing Situation of Workers and Their Unions, Washington, D.C. AFL-CIO, 1985, 10. 23. Paul Weiler, Governing the Workplace, Cambridge, Harvard University Press, 1990, 238-39. 24. B&A, Unions Today, New Tactics to Tackle Tough Times, Washington, D.C. Bureau of National Affairs, 1985, 12. 25. E.g., Robert Schrank, Are Unions an Anachronism? Harvard Business Review 57, Sept. October 1970, 107-8. 26. E.g., Eugene Forsey, Trade Unions in 2020? Visions 2020, Stephen Clarkson ed., Edmonton, M. G. Hertig, 1970, 94. 27. Richard Freeman and James Meadow, What Do Unions Do? New York. Basic Books, 1984, 43-77. 28. Ibid. 150-53. 29. Ibid. 94-110. 30. Charles Craver, The Inquisitorial Process in Private Employment, Cornell Law Review 63, 1977, 6. 31. Daniel Fishel, Labor Markets and Labor Law Compared with Capital Markets and Corporate Law, University of Chicago. Law Review 51, 1984, 1062. 32. Richard Freeman and James Meadow, What Do Unions Do? 7. 33. Marion Crane, Building Solidarity Through Expansion of NLRA Coverage, A Blueprint for Worker Empowerment, Minnesota. Law Review 74, 1990, 968-69. 2. The Historical Foundation of American Labor 1. The general information discussed in this chapter is taken from various sources. John Commons and Associates, History of Labor in the United States, New York. Macmillan, 1918, Albert Bloom, A. History of the American Labor Movement, Washington, D.C. American Historical Association, 1972, Foster Dulles and Melvin. Dubofsky, Labor in America, Arlington Heights, 111, Harlan. Davidson, 4th ed., 1984, Philip Foner, Women in the American Labor Movement, New York. Free Press, 1982, William Forbath, The Shaping of the American Labor Movement, Harvard Law Review 102, 1989, 1109. Samuel Gompers, 70 Years of Life and Labor, New York. E. P. Dutton, 1925, Richard Morris. Government and Labor in Early America, New York. Columbia University Press, 1946. Selig Perlman, A History of Trade Unionism in the United States. New York. Macmillan, 1935, Selig Perlman and Philip Taft, History of Labor in the United States, 1896-1932, New York. Macmillan, 1935, Philip Taft, Organized Labor in American History, New York. Harper and Row, 1964, Lloyd Ullman, The Rise of the National Trade Union, Cambridge, Harvard University Press, 1955. 2. 45 Mass. 4 Met. 111, 38 Am. Dec. 346, 1842. This landmark decision is extensively explored in Walter Nell's Commonwealth v. Hunt, Columbia Law Review 32, 1932, 1128. 3. Philip Foner, Women in the American Labor Movement, New York. Free Press, 1982, 61. 4. Ibid. 87. 5. Selig Perlman, A History of Trade Unionism in the United States. New York. Macmillan, 1935, 95. 6. Ibid. 111. 7. Philip Taft, Organized Labor in American History, New York. Harper and Row, 1964, 117. 8. Samuel Gompers, Judicial Vindication of Labor's Claims. American Federationist 7, 1901, 284. 9. Ibid. 1136. 10. 39 Stat. 721, 1916. 11. 243 U.S. 332, 1917. 12. 47 Stat. 70, 1932. 13. 313 U.S. 177, 187, 1941. 14. 208 U.S. 161, 1908. 15. David Montgomery, The Fall of the House of Labor, New York. Cambridge University Press, 1987, 270. 16. Ibid. 17. Ibid. 271. 18. Ibid. 19. 38 Stat. 730, 1914. 20. Samuel Gompers, The Charter of Industrial Freedom. American Federationist 21, 1914, 971. 21. 38 Stat. 731, 1914, Cody ed. at 15 U.S.C. Section 17. 22. 254 U.S. 443, 1921. 23. Philip Taft, Organized Labor in American History, 29024. Barbara Ehrenreich, Fear of Falling, New York, Harper. Perennial, 1990, 134. 25. Philip Taft, Organized Labor in American History, 336. 26. Donna Van Raphorst, Union Maids Not Wanted, Organizing. Domestic Workers 1870 to 1940. New York. Prager, 1988, 165. 27. Ibid. 28. Ibid. 166. 29. Philip Foner, Women in the American Labor Movement, 247. 30. Alice Kessler Harris, Out to Work, New York, Oxford. University Press, 1982, 157. 31. Philip Taft, Organized Labor in American History, 668. 32. Barbara Ehrenreich, Fear of Falling, 134. 33. Ibid. 135. 34. David Montgomery, The Fall of the House of Labor, 416. 35. Ibid. 419 to 20. 36. Donna Van Raphorst, Union Maids Not Wanted, Organizing. Domestic Workers 1870 to 1940, 177. 37. George Barnett, American Trade Unionism and Social Insurance, American Economic Review 23, March 1933, 6. 38. 25 Stat. 501, 1888. 39. 30 Stat. 424, 1898. 40. 38 Stat. 103, 1913. 41. 41 Stat. 456, 1920. 42. 44 Stat. 577, 1926. 43. 49 Stat. 1189, 1936. 44. 48 Stat. 198, 1933. 45. 295 U.S. 495, 1935. 46. 49 Stat. 449, 1935. The NLRA is Cody ed. at 29 U.S.C. Sections 151 to 69. 47. 301 U.S. 1, 1937. 48. The industrial unions generally ignored the female clerical personnel working in these industries. 49. Philip Taft, Organized Labor in American History, 472. 50. Paul Weiler, Governing the Workplace, Cambridge, Harvard. University Press, 1990, 9. 51. Business experts have estimated that the enactment of the NLRA caused a 15.9% decline in shareholder wealth. Craig, Olson and Brian Becker, The EECTS of the NLRA on Stockholder Wealth in the 1930s, Industrial and Labor Relations Review 44, October. 1990, 116. 52. 306 U.S. 240, 1939. 53. NLRB-V. Montgomery Ward and Company, 157 F2D 486, 8th CIR. 1946. Elk Lumber Company, 91 NLRB 333, 1950. 54. C. G. Con. Limited v. NLRB 108 F2D 390. 7th CIR 1939. 55. UAW Local 232 v. Wisconsin Employment Relations Board 336 US 245. 1949. 56. NLRB v. McKay Radio and Telegraph Company 304 US 333. 1938. 57. 346 US 464. 1953. 58. Patterson Sargent Company 115 NLRB 1627. 1956. 59. 351 US 105. 1956. 60. 61 Stat. 136. 1947. 61. 330 US 485. 1947. 62. 73 Stat. 519. 1959. 63. Philip Taft, Organized Labor in American History, 658. 64. Ibid. 661. 65. 77 Stat. 56. 1963. 66. 78 Stat. 253. 1964. 67. 81 Stat. 602. 1967. 68. 84 Stat. 1590. 1970. 69. 88 Stat. 832. 1974. 70. 104 Stat. 327. 1990. 71. Thomas Edsall, The New Politics of Inequality, New York. W. W. Norton, 1984, 107-8. 72. Charles Morris, The Developing Labor Law, Washington, D.C. Bureau of National Heirs, 2D ed., 1983, 66-67. 73. Thomas Edsall, The New Politics of Inequality, 156. 3. The Extent and Causes of the Decline 1. Philip Taft, Organized Labor in American History, New York. Harper and Row, 1964, 162. 2. Michael Gold Eld, The Decline of Organized Labor in the United States. Chicago, University of Chicago Press, 1987, 8. 3. Ibid. 10 Table 1. 4. George Barnett, American Trade Unionism and Social Insurance, American Economic Review 23, March 1933, 6, Lyle. Cooper, The American Labor Movement in Prosperity and Depression, American Economic Review 22, December 1932, 653-54. 5. Michael Gold Eld, The Decline of Organized Labor in the United States, 10 Table 1. 6. Ibid. 7. Ibid. 11 Table 2. 8. Ibid. 9. Ibid. 23 Figure 4. 10. Ibid. 16 Table 3. 11. Michael Kerm, Barry Hirsch and David McPherson, Union. Membership and Contract Coverage in the United States, 19,831,988, Industrial and Labor Relations Review 44, October 1998. 12. BNA, Daily Labor Report 26, February 7, 1991, B-8. 13. Ibid. 14. Ibid. B10 Table 2. 15. Ibid. B-8. 16. BNA, Daily Labor Report 69, April 10, 1991, AL. 17. Ibid. DL. 18. Ibid. A2. 19. Ibid. D2. 20. Richard Freeman and James Meadow, What Do Unions Do? New York. Basic Books, 1984, 202-3. 21. Thomas Cochin, Harry Katz and Robert McCursey, The Transformation of American Industrial Relations, New York. Basic Books, 1986, 128-29. 22. Barbara Ehrenreich, The Worst Years of Our Lives, New York. Pantheon Books, 1990, 203. 23. Sheena McConnell, Cyclical Fluctuations in Strike Activity, Industrial and Labor Relations Review 44, October 1990, 130. 24. Marion Crane, Building Solidarity Through Expansion of NLRA Coverage, A Blueprint for Worker Empowerment, Minnesota. Law Review 74, 1990, 956. 25. Charles Heckscher, The New Unionism, Employee Involvement in the Changing Corporation, New York. Basic Books, 1988, 30. 26. United States Department of Labor, Employment in Perspective. Women in the Labor Force, First Quarter 1990. 27. Peter Morrison, Beyond the Baby Boom, The Futurist 13 April 1979 133. 28. Ibid. 29. Commission on Workforce Quality and Labor Market. Ishan C. Investing in People, Washington, D.C., U.S. Department of Labor, 1989, 26. 30. William Johnston and Arnold Packer, Workforce 2000, Indianapolis. Hudson Institute, 1987, XX. 31. Diane Bailser, Sisterhood and Solidarity, Boston, South End. Press, 1987, 21. 32. Daniel Hammermesh and Albert Rees, The Economics of Work and Pay, New York. Harper and Row, 4th ed. 1988, 367-76. 33. William Johnston and Arnold Packer, Workforce 2000, 89. 34. Daniel Hammermesh and Albert Rees, The Economics of Work and Pay, 347-59. 35. Santa of Senate Special Committee on Aging, 101st. Congress, First Session, Aging America, Trends and Projections, Committee Print, 1988, 8. 36. BNA, Older Americans in the Workforce, Challenges in Solutions, Washington, D.C., Bureau of National Affairs, 1987, 5. 37. Ibid. 15. 38. Santa of Senate Special Committee on Aging, 101st. Congress, First Session, Aging America, Trends and Projections, 39. Table 2-1. 39. Ibid. 47-48. Table 2-5. 40. Diane Hers, Employment Characteristics of Older Women, Monthly Labor Review 111, September 1988, 4. 41. 100 Stat. 3342, 1986. Cody ed. at 29 U.S.C. Section 631, A. 42. Jeremy Rifkin and Randy Barber, The North Will Rise Again, Boston. Beacon Press, 1978, 59-68. 43. Thomas Cocken, Harry Katz and Robert McCursey, The Transformation of American Industrial Relations, 67-68. 44. Sanford Cohen, Labor in the United States, Columbus, Ohio. Merrill Publishing, 5th ed., 1979, 97. 45. Alvin Terrer, The Third Wave, New York. William Morrow, 1980, 139. 46. Ibid. 47. Giles Radis, The Industrial Democrats, Boston, Allen N. Unwin, 1978, 34. 48. Richard Barnett and Ronald Muller, Global Reach, The Power of the Multinational Corporations, New York. Simon & Schuster, 1974, 323. 49. William Johnston and Arnold Packer, Workforce 2000, 96-97. Viktor Kosolopov, Mankind in the Year 2000, Moscow. Progress, 1976, 156. 50. Ronald Kutcher and Valerie Personic, Deindustrialization and the Shift to Services, Monthly Labor Review 109, June 1986, 4. 51. Careers for the Long Haul, Newsweek on Campus, Sept. 1986, 17. 52. William Johnston and Arnold Packer, Workforce 2000, 61. Burnham Beckwith, The Next 500 Years, New York. Exposition Press, 1967, 86-87. 53. Alvin Terrer, The Third Wave, 181-83, 190-92. 54. Swasti Mitter, Common Fate, Common Bond, Oxford, Pluto. Press, 1986, 136. 55. George Hildebrand, American Unionism, and Historical and Analytical Survey, Reading, Mass. Addison Wesley, 1979, 118-19. 56. Gary Gabbard, Post-Eowens, The Turbulent Transition to a Post-Industrial Society, Future State, October 1974, 214. 57. G. B. J. Bomers, Multinational Corporations and Industrial Relations, Assen, Netherlands. Van Gorkum, 1976, 9-10. 58. Robert Cox, Labor and the Multinationals, Foreign Affairs 54, January 1976, 345-47. 59. Giles Radis, The Industrial Democrats, 40. 60. Lewis Turner, Invisible Empires, Multinational Companies in the Modern World, New York. Harcourt Brace Jovanovich, 1970, 191. 61. Terence Killingsworth, American Labor Policy in the International Economy, Clarifying Policies and Interests, Boston. College Law Review 31, 1989, 91. 62. Ibid. 63. Richard Barnett and Ronald Muller, Global Reach, The Power of the Multinational Corporations, 304. Jeremy Rifkin and Randy Barber. The North Will Rise Again, 31. 64. International Labor OCE, Multinational Enterprises in Social Policy, Geneva. International Labor OCE, 1973-77. 65. Robert Reich, The Work of Nations, New York, Alfred. Knopf, 1991, 113. 66. Swasti Mitter, Common Fate, Common Bond, 38-40. Annette Fuentes and Barbara Ehrenreich, Women in the Global Factory, Boston. South End Press, 1983, 16-17. 67. Swasti Mitter, Common Fate, Common Bond, 38-39. 68. United States International Trade Commission, TARI. Schedules of the United States Annotated, 1986, Item 800.00. Terence Killingsworth, American Labor Policy in the International Economy. Clarifying Policies and Interests, Boston. College Law Review 31, 1989, 80-81. 69. Swasti Mitter, Common Fate, Common Bond, 23, Annette Fuentes and Barbara Ehrenreich, Women in the Global Factory, 12-13. 70. Swasti Mitter, Common Fate, Common Bond, 54. 71. Annette Fuentes and Barbara Ehrenreich, Women in the Global Factory, 27-29. 72. Sandy Tolan, Hope and Heartbreak, New York Times Magazine, July 1, 1990, 19. 73. Lawrence Rothstein, Plant Closings, Dover, Mass., Auburn. House Publishing, 1986, 14. 74. Robert Reich, The Work of Nations, 120. 75. Ibid. 122. 76. Ibid. 77. Nathaniel Goldinger, An American Trade Union View of International Trade and Investment in American Labor and the Multinational Corporation, Dwayne Kujawa ed. New York. Prager, 1973, 34. 78. Robert Reich, Who Is Us? Harvard Business Review 68, Jan. February 1990, 79. Ibid. 61-62. 80. Swasti Mitter, Common Fate, Common Bond, 8-9. 81. Robert Reich, Who Is Us? Harvard Business Review 68, Jan. February 1990, 58. 82. Charles Levinson, International Trade Unionism, London. Allen and Unwin, 1972, 222. 83. James Allison, Reactions on Labor, Power and Society. Maryland Law Review 44, 1985, 845. 84. Ibid. 842-45. 85. Terence Killingsworth, American Labor Policy in the International Economy. Clarifying Policies and Interests, Boston. College Law Review 31, 1989, 62. 86. Bruno Amoroso, A Danish Perspective, The Impact of the Internal Market on the Labor Unions and the Welfare State. Comparative Labor Law Journal 11, 1990, 485. 87. E.g., in Ray Jacobs, 98 NY 98, 1885, Striking Down New York Law Prohibiting Cigar Manufacturing in Tenement Dwellings. Ritchie v. People, 155,111, 98, 40 NE 454, 1895, invalidating. Illinois 8-Hour Law, Adair v. United States, 208 U.S. 161, 1908. Voiding federal law proscribing yellow dog contracts. 88. 49 Stat. 449, 1935. 89. The constitutionality of the NLRA was sustained in NLRB v. Jones and Laughlin Steel Corp. 301 U.S. 1, 1937. 90. Philip Taft, Organized Labor in American History, 452-55. 91. 29 U.S.C. Section 158, A. 1. 92. Paul Weiler, Governing the Workplace, Cambridge, Harvard University Press, 1990, 238. 93. Ibid. 238 N. 18. 94. 29 U.S.C. Section 158, A. 3, prohibits employer discrimination intended to encourage or discourage support for labor organizations. 95. Paul Weiler, promises to keep securing workers' rights to self-organization under the NLRA, Harvard Law Review 96, 1983, 1780-81. 96. Paul Weiler, Governing the Workplace, 238-39. 97. Robert Lalonde and Bernard Meltzer, Hard Times for Unions. Another look at the significance of employer illegalities. University of Chicago Law Review 58, 1991, 994 Table 7. 98. Paul Weiler, Governing the Workplace, 239n, 19. 99. Richard Freeman and James Meadow, What Do Unions Do? 233. 100. Midland National Life Insurance Company, 263 NLRB 127, 1982. 101. Michael Gold Eld, The Decline of Organized Labor in the United States, 52 Table 10. 102. Ibid. 103. Thomas Cochin, Harry Katz and Robert McCursey, The Transformation of American Industrial Relations, 66-73. 104. Ibid. 69-75. 105. Jonathan Axelrod, Common Obstacles to Organizing. Under the NLRA, Combating the Southern Strategy, North Carolina Lave Review 59, 1980, 147. 106. Michael Gold Eld, The Decline of Organized Labor in the United States, 190-91. 107. Ibid. 190. 108. David Blanche Ower and Richard Freeman, Going d'Errant Ways. Unionism in the U.S. and Other Advanced OECD Countries, Cambridge, Massachusetts. National Bureau of Economic Research Working. Paper 3342, April 1990, 9-10. 109. Richard Freeman and James Meadow, What Do Unions Do? 43-54. 110. BNA, Daily Labor Report 161, August 20, 1990, A4. 111. Anil Verma and Thomas Cochin, The Growth and Nature of the Non-Union Sector Within a Firm, Challenges and Choices. Facing American Labor, Thomas Cochin, ed. Cambridge, MIT. Press, 1985, 101. 112. Richard Freeman and James Meadow, What Do Unions Do? 162-69. 113. C. Wright Mills, White Collar, New York, Oxford. University Press, 1951, 294. Benjamin DeMott, The Imperial. Middle, New York. William Morrow, 1990, 41-42, 130-31. 114. Stanley Aronowitz, False Promises, New York. McGraw-Hill, 1973, 141. Lyle Cooper, The American Labor Movement in Prosperity and Depression, American Economic Review 22, Dec. 1932, 646. 115. Michael Mann, Consciousness and Action Among the Western Working Class, Atlantic Highlands, N.J., Humanities Press, 1973, 30-31. 116. C. Generally William Ryan, Blaming the Victim, New York. Vintage Books, 1976. 117. Ibid. 10-11. 118. Barbara Ehrenreich, Fear of Falling, New York, Harper. Perennial, 1990. 108-9. 119. Ibid. 140-41. 120. Richard Freeman and James Meadow, What Do Unions Do? 214-17. 121. C. Wright Mills, White Collar, 319. Stanley Aronowitz. False Promises, 292-93. 122. C. Wright Mills, White Collar, 297. Elizabeth Jellin, The Concept of Working Class Embourgeoisement, The American Working Class, Irving Horowitz, John Leggett and Martin Oppenheimer, eds. New Brunswick, N.J. Transaction Books, 1979, 247-51. 123. Barbara Ehrenreich, The Worst Years of Our Lives, 196-97. 124. C. Wright Mills, White Collar, 63. 125. Michael Gold Eld, The Decline of Organized Labor in the United States, 50. 126. Edna Bonachich, A Theory of Ethnic Antagonism, The Split Labor Market, The American Working Class, Irving Horowitz. John Leggett and Martin Oppenheimer, eds. 82. 127. Robert Bibb, Blue-Collar Women in Low-Wage Industries. A Dual Labor Market Interpretation, The American Working Class, Irving Horowitz, John Leggett and Martin Oppenheimer, eds. 13,233. 4. The Need for Labor Unions 1. Jeremy Rifkin and Randy Barber, The North Will Rise Again, Boston. Beacon Press, 1978, 20. 2. John Dunlop, Past and Future Tendencies of American Labor Organizations, Daedalus, Winter 1978, 84. 3. George Hardbeck, Unionism Again at a Crossroads, Critical Issues in Labor. Max Wertman Jr., ed. New York. Macmillan, 1969, 67-68. Julius Schister, The Outlook for Union Growth, The Annals 350, 1963, 56-57. 4. Michael Gold Eld, The Decline of Organized Labor in the United States. Chicago, University of Chicago Press, 1987, 35. 5. B&A, Labor Relations Reporter 130, February 27, 1989, 244. 6. Annette Fuentes and Barbara Ehrenreich, Women in the Global Factory, Boston. South End Press, 1983, 48-53. 7. Thomas Carrier, Unions and the U.S. Comparative Advantage, Industrial Relations 30, Winter 1991, 1. See generally. Lawrence Mischel and Paula Vuz, Unions and Economic Competitiveness, Armonk, N.Y., M. E. Sharp, 1992. 8. Richard Freeman and James Meadow, What Do Unions Do? New York. Basic Books, 1984, 214-15. 9. C29 U.S.C. Section 504, A. 10. B&A, Daily Labor Report 124, June 27, 1991, A12. 11. B&A, Daily Labor Report 101, May 26, 1992, AL, B&A. Daily Labor Report 240, December 13, 1991, ALL. 12. Robert Reich, The Work of Nations, New York, Alfred. Knopf, 1991, 7. 13. Ibid. 14. Richard Freeman and James Meadow, What Do Unions Do? 145. 15. Ibid. 16. B&A, Unions Today, New Tactics to Tackle Tough Times, Washington, D.C. Bureau of National Affairs, 1985, 11. 17. Thomas Cochin, Harry Katz and Robert McCursey, The Transformation of American Industrial Relations, New York, Basic Books, 1986, 216. 18. Ibid. 217. 19. Richard Barnett, A Reporter at Large, New Yorker, April 7, 1980, 78. 20. Solomon Barkin, A New Agenda for Labor, Fortune, November 1960, 250-52. 21. Worker Adjustment and Retraining Notee Cation Act, Pub. L. 100-379, 102 Stat. 890, 1988. 22. See generally Paul Osterman, Elements of a National Training Policy, New Developments in Worker Training. A Legacy for the 1990s, Louis Furman, Michelle Hoyman, Joel Kutcher-Gershenfeld and Ernest Savoy, eds. Madison, Wisconsin. Industrial Relations Research Association, 1990, 257. 23. Pub. L. 100-690, 102 Stat. 4304, 1988. 24. See generally Mark Rothstein, Workplace Drug Testing, A. Case Study in the Misapplication of Technology, Harvard Journal of Law and Technology 5, 1991, 65. 25. The Drug-Free Workplace Act currently indicates that rehabilitation may constitute a sanction for workers found to be abusing drugs or alcohol. 41 U.S.C. Section 702, A. 1, F. This provision could be Modi ed to require rehabilitation for all RST time abusers. 26. Commission on Workforce Quality and Labor Market. Ishan C. Investing in People, Washington, D.C., U.S. Department of Labor, 1989, 2. 27. Sar Levitan and Frank Gallo, Uncle Sam's Helping Hand. Educating, Training, and Employing the Disadvantaged, New Developments in Worker Training. A Legacy for the 1990s, Louis Furman, Michelle Hoyman, Joel Kutcher-Gershenfeld and Ernest Savoy, eds. 226. 28. Ibid. 29. Frank L. Corey and Edna L. Corey, How Arbitration Works, Washington, D.C. Bureau of National Affairs, 1985, 650-53. 30. Howard Specter and Matthew Finken, Individual Employment, Law and Litigation, Charlottesville, VA. Mitchie Company, 1989, 1-18,889. 31. See generally Cornelius Peck, Unjust Discharges from Employment. A Necessary Change in the Law, Ohio State Law. Journal 40, 1979, 1. 32. Jack Stieber, Recent Developments in Employment at Will, Labor Law Journal 36, 1985, 558. 33. See generally Theodore Street, Antoine, A Seed Germinates. Unjust Discharge Reform Heads Toward Full Flower, Nebraska Law. Review 67, 1988, 56. The National Conference of Commissioners on Uniform State Laws recently adopted a model uniform Employment Termination Act that should encourage states to act in this area. BNA, Daily Labor Report 156, August 13, 1991, DL. 34. Robert Rabin, The Role of Unions in the Rights-Based Workplace, University of San Francisco Law Review 25, 1991, 171. 35. Carl Clare, Workplace Democracy and Market Reconstruction, An Agenda for Legal Reform, Catholic University. Law Review 38, 1988, 58. 36. Ibid. 206-7. 37. BNA, Daily Labor Report 39, February 28, 1984, A5. 38. Jaray Keefe, Do Unions Influence the Diffusion of Technology? Industrial and Labor Relations Review 44, 1991, 261. 39. Joseph Coates, Jennifer Jarrett and John Mahal-E, Future Work, The Futurist 25 May-June 1991, 15. 40. Gus Tyler, The Labor Revolution, New York, Viking Press, 1967, 126-27. 41. Where You Can't Get Fired, U.S. News and World Report 110, January 14, 1991, 46. 42. Lawrence Rothstein, Plant Closings, Dover, Mass., Auburn. Publishing, 1986, 16. 43. Lloyd Ullman, Multinational Unionism, Incentives, Barriers and Alternatives, Industrial Relations 14, 1975, 27. 44. Louis Furman, Michelle Hoyman and Joel Kutcher-Gershenfeld, Joint Union Management Training Programs, A. Synthesis in the Evolution of Jointism and Training, New Developments in Worker Training. A Legacy for the 1990s, Louis Furman, Michelle Hoyman, Joel Kutcher-Gershenfeld and Ernest Savoy, eds. 157, Thomas Pascoe and Richard Collins, UAW Ford. Employee Development and Training Program, Overview of Operations and Structure, Labor Law Journal 36, 1985, 519. 45. Commission of Workforce Quality and Labor Market. Ishan C., Investing in People, Washington, D.C., U.S. Department of Labor, 1989, 16. 46. Margaret Hilton, Shared Training, Learning from Germany, Monthly Labor Review 114, March 1991, 34. 47. Anthony Carnevale and Harold Goldstein, Schooling and Training for Work in America, An Overview, New Developments in Worker Training. A Legacy for the 1990s, Louis Furman, Michelle Hoyman, Joel Kutcher-Gershenfeld and Ernest Savoy, eds. 30. 48. Richard Freeman and James Meadow, What Do Unions Do? 228-29. Michael Gold-Eld, The Decline of Organized Labor in the United States, 206. 49. American Hospital Association v. NLRB, 111s. Court 1539, 1991. 50. BNA, Labor Relations Reporter 136, April 29, 1991, 497. 51. Ibid. 52. 444 U.S. 672, 1980. 53. College of Osteopathic Medicine and Surgery, 265 NLRB 295, 1982. 54. The inappropriateness of the yeshiva decision is discussed in Chapter 6, below. 55. See generally Jules Bernstein, Union Busting, From Benign Neglect to Malignant Growth, University of California, Davis Law. Review 14, 1980, 1. 56. Julius Getman, Ruminations on Union Organizing in the Private Sector, University of Chicago Law Review 53, 1986, 50. 57. Solomon Barkin, The Decline of the Labor Movement, Santa Barbara, Cal. Center for the Study of Democratic Institutions, 1961, 58. 58. Derek Bach and John Dunlop, Labor and the American Community, New York. Simon & Schuster, 1970, 469. 59. Gus Tyler, The Labor Revolution, New York, Viking Press, 1967, 9. 60. Everett Cassellow, White-Collar Unionism in the United States, White-Collar Trade Unions, Adolf Sturmthal, ed. Urbana, 111. University of Illinois Press, 1966, 362. 61. Lois Gray and Joyce Kornblue, New Directions in Labor Education, New Developments in Worker Training, A Legacy for the 1990s. Louis Furman, Michelle Hoyman, Joel Kutcher Gershenfeld in Ernest Savoy, eds. 95. 62. Ibid. 112. 63. Julius Getman, Ruminations on Union Organizing in the Private Sector, University of Chicago Law Review 53, 1986, 60. 64. Hoyt Wheeler and John McClendon, The Individual Decision to Unionize, The State of the Unions, George Strauss, Daniel Gallagher and Jack Fiorito, eds. Madison, Wisconsin, Industrial Relations. Research Association, 1991, 66. 65. Ibid. 66. B&A, Labor Relations Reporter 138, December 9, 1991, 475, citing the unpublished work of Professor Kate Bronfenbrenner. 67. Philip Foner, Women in the American Labor Movement, New York, Free Press, 1982, 265. 68. Ibid. 270-72. 69. Ibid. 260, quoting Yuri Kuwahara. 70. AFL-CIO Committee on the Evolution of Work, The Changing Situation of Workers and Their Unions, 1985, 28. 71. B&A, Unions Today, New Tactics to Tackle Tough Times, 100-101. 72. William Johnston and Arnold Packer, Workforce 2000, Indianapolis, Hudson Institute, 1987, 59. 73. Richard Freeman, Why Are Unions Faring Poorly in NLRB? Representation Elections? Challenges and Choices Facing American Labor, Thomas Cockin, ed. Cambridge, MIT Press, 1985, 51. 74. Article 20 of the AFL-CIO Constitution. See Generally Lee Vaughan, Article 20 of the AFL-CIO Constitution, Managing and Resolving Inter-Union Disputes, Wayne Law Review 37, 1990, 1. 75. Many employers have intentionally transferred production to southern states or have opened new facilities in that region because of the limited degree of unionization among southern workers. Jonathan Axelrod, Common Obstacles to Organizing. Under the NLRA, Combating the Southern Strategy, North Carolina. Law Review 59, 1980, 148. 76. Calvin Beal, Renewed Growth in Rural Communities. Futurist 9, August 1975, 196. 77. Unions Still Find the South a Tough Row to Hoe, U.S. News and World Report, June 21, 1982, 62. 78. Michael Gold eld. The Decline of Organized Labor in the United States, 14,042. 79. B&A, Labor Relations Reporter 129, November 7, 1988, 302. 80. Ibid. 303-4. 81. William Johnston and Arnold Packer, Workforce 2000, XX. 82. B&A, Older Americans in the Workforce, Challenges and Solutions, Washington, D.C. Bureau of National Affairs, 1987, 5. 83. B&A, Labor Relations Reporter 138, December 9, 1991, 476, citing the unpublished work of Professor Kate Bronfenbrenner. 84. U.S. Department of Labor, Time of Change, 1983 Handbook on Women Workers, Washington, D.C., U.S. Government Printing, OCE, 1983, 50. 85. Ibid. 86. Ibid. 48. 87. James Meadow, AFL-CIO Study on Public Image of Unions. B&A, Daily Labor Report 247, December 24, 1984, D2. 88. Philip Foner, Women in the American Labor Movement, 492-93. 89. See generally Diane Bailser, Sisterhood and Solidarity, Boston, South End Press, 1987, 151-61. 90. Ibid. 43-51. Arthur Shostak, Robust Unionism, Ithaca, NY. ILR Press, 1991, 85-87. 91. Edna Raphael, Working Women and Their Membership in Labor Unions, The American Working Class, Irving Horowitz, John. Leggett and Martin Oppenheimer, eds. New Brunswick, NJ. Transaction Books, 1979, 114, Roberta Goldberg, Organizing. Women OCE Workers, New York. Prager, 1983, 22-25. 92. William Johnston and Arnold Packer, Workforce 2000, 11,213. 93. U.S. Department of Labor, Time of Change, 1983 Handbook on Women Workers, 54. 94. See generally Daniel Hammermatch and Albert Rees, The Economics of Work and Pay, New York, Harper and Row, 1988, 36776. 95. Note. Finding a Voice Through the Union, the Harvard Union of Clerical and Technical Workers and Women Workers. Harvard Women's Law Journal 12, 1989, 274-75. 96. Ibid. 275, Marion Crane, Feminizing Unions. Challenging the Gendered Structure of Wage Labor. Michigan Law Review 89, 1991, 1155. Diane Bailser, Sisterhood and Solidarity, 16-17. 97. Solomon Barkin, A New Agenda for Labor, Fortune, November. 1960, 255. See generally William Gould, Black Workers in White Unions. Job Discrimination in the United States, Ithaca, Cornell University Press, 1977, F. Ray Marshall, The Negro and Organized Labor, New York. John Wiley and Sons, 1965. 98. Pub. L. 88-352, 78 Stat. 253, 1964. 99. James Meadow, AFL-CIO Study on Public Image of Unions. BNA, Daily Labor Report 247, December 24, 1984, D2. 100. Steve Askin, Turmoil in the Ranks, Black Enterprise, September 1982, 59-60. 101. Under the Age Discrimination in Employment Act, as amended, companies may no longer require the involuntary retirement of employees. See 29 U.S.C. Section 631, A. See generally. Charles Craver, The Application of the Age Discrimination in Employment Act to Persons Over 70, George Washington Law. Review 58, 1989, 52. 102. BNA, Unions Today, New Tactics to Tackle Tough Times, 124. 103. David Rabin, Distinguishing Excluded Managers from Covered Professionals under the NLRA, Columbia Law Review 89, 1989, 1777. 104. See generally Harry Edwards, R. Theodore Clark and Charles Craver, Labor Relations Law in the Public Sector, Charlottesville, VA. Mitchie Company, 1991, 1-32. 105. Michael Piori, The Future of Unions, The State of the Unions, George Strauss, Daniel Gallagher and Jack Fiorito, eds. 406. 106. Seymour Lipset, White Collar Workers and Professionals, Their Attitudes and Behavior Towards Unions, readings in Industrial Sociology, William Fonts, ed. New York. Appleton Century Crofts, 1967, 530-31. 107. Ibid. 525, 534-35. 108. David Rabin, Distinguishing Excluded Managers from Covered Professionals under the NLRA, Columbia Law Review 89, 1989, 1832. 109. Alice Kessler Harris, Education in Working Class. Solidarity. The Summer School for OCE Workers, Sisterhood and Solidarity. Joyce Kornblue and Mary Frederickson, eds. Philadelphia. Temple University Press, 1984, 225-26, c. Wright, Mills, White Collar, New York. Oxford University Press, 1951, 2045. 110. Alvin Terrer, Power Shift, New York. Bantam Books, 1990, 209. 111. Robert Reich, The Work of Nations, 177-78. 112. Ibid. 204. 113. Ibid. 214. 114. Donna Sokol, The Future of Labor Law, A Mismatch Between Statutory Interpretation and Industrial Reality, Boston. College Law Review 30, 1989, 997. 115. Michael Gold Eld, The Decline of Organized Labor in the United States, 147. 116. Charles Heckscher, The New Unionism, Employee Involvement in the Changing Corporation, New York. Basic Books, 1988, 240. 117. Michael Mann, Consciousness and Action Among the Western Working Class, Atlantic Highlands, N.J., Humanities Press, 1981, 66. 118. Everett Cassellow, White Collar Unionism in the United States, White Collar Trade Unions, Adolf Sternthal, ed. 317-30, 351-55. Ronald Miller, Collective Bargaining in Financial Institutions, Employee Relations Law Journal 7, 1981-82, 389. 119. Anthony Giddens, The Class Structure of the Advanced Societies, New York. Barnes & Noble, 1973, 188-92, Everett. Cassillo, Trade Unions and Industrial Relations, an International Comparison, New York. Random House, 1969, 208-16. Regarding the unionization of white-collar workers in Specie countries, C.K. F. Walker, White-Collar Unionism in Australia, White-Collar Trade Unions, Adolf Sternthal, ed. 1. Guy Ruth, White-Collar Unions in the United Kingdom, White-Collar Trade Unions, Adolf Sternthal, ed. 165, Gunter Hart, Germany, White-Collar Trade Unions, Adolf Sternthal, ed. 127, Arne Nilstein, White-Collar Unionism in Sweden, White-Collar Trade Unions, Adolf Sternthal, ed. 261, Solomon Levine, Unionization of White-Collar Employees in Japan, White-Collar Trade Unions, Adolf Sternthal, ed. 205, 120. David Rabin, Can American Labor Law Accommodate Collective Bargaining by Professional Employees? Yale Law Journal 99, 1990, 691. Paul Jarley and Jack Fiorito, Unionism and Changing Employee Views Toward Work, Journal of Labor. Research 12, 1991, 226. See generally David Rabin, Is Unionism compatible with professionalism, industrial and labor relations? Review 45, October 1991, 97. 121. Marion Crane, Building Solidarity Through Expansion of NLRA Coverage, A Blueprint for Worker Empowerment, Minnesota. Law Review 74, 1990, 994. 122. Sar Levitan and Frank Gallo, Collective Bargaining and Private Sector Professionals, Monthly Labor Review 112, Sept. 1989, 24. 123. Marina Angel, Professionals in Unionization, Minnesota. Law Review 66, 1982, 383. 124. Daniel Gallagher and George Strauss, Union Membership. Attitudes and Participation, The State of the Unions, George Strauss, Daniel Gallagher and Jack Fiorito, eds. 143, Michael Mann. Consciousness and Action Among the Western Working Class, 25,125. C. Wright Mills, White Collar, 301-2, 312. 126. Stanley Aronowitz, False Promises, New York. McGraw-Hill, 1973, 312-13. 127. 29 U.S.C. Section 159, A, provides that representatives designated or selected by the majority of the employees in a unit shall be the exclusive representatives of all the employees in such unit for the purposes of collective bargaining. 128. C, e.g., International Ladies Garment Workers Union v. NLRB, 366 U.S. 731, 1961, J.I. Case Company v. NLRB, 321 U.S. 332, 1944. 129. Stanley Aronowitz, False Promises, New York. McGraw-Hill, 1973, 151-52. 130. C. Wright Mills, White Collar, 139. 131. AFL-CIO Committee on the Evolution of Work, The Changing Situation of Workers and Their Unions, 18-20. 132. Robert Rabin, The Role of Unions in the Rights-Based Workplace, University of San Francisco Law Review 25, 1991, 2089. 133. Jack Fiorito, Cynthia Graham and Wallace Hendricks, Union Structural Choices, The State of the Unions, George Strauss. Daniel Gallagher and Jack Fiorito, eds. 126-27. 134. BNA, Daily Labor Report 123, June 26, 1991, A15. 135. Charles Heckscher, The New Unionism, Employee Involvement in the Chong-Ing Corporation, New York, Basic Books, 1988, 188. 136. BNA, Labor Relations Reporter 124, January 19, 1987, 40. 137. See generally Sar Levitan and Frank Gallo, Can Employee Associations Negotiate New Growth? Monthly Labor Review 112, July 1989, 5. 138. 925 F2D 480, DC. CIR 1991. 139. 26 U.S.C. Section 511, A, 1. 140. 925 F2D at 481. 5. Enhancing Organized Labor's Power 1. Section 8, D. 29 U.S.C. Section 158, D. 2. NLRB v. Katz, 369 U.S. 736, 741-43, 1962. See generally. Florian Bartosich and Roger Hartley, Labor Relations Law in the Private Sector, Philadelphia. American Law Institute, 1986, 301-6. 3. NLRB v. American National Insurance Company, 343 U.S. 395, 4029, 1952. See generally. Archibald Cox, The Duty to Bargain in Good Faith, Harvard Law Review 71, 1958, 1418-28. 4. H. K. Porter Company v. NLRB, 397 U.S. 99, 108, 1970. 5. NLRB v. International Van Lines, 409 U.S. 48, 52-53, 1972. 6. NLRB v. McKay Radio and Telegraph Company, 304 U.S. 333, 345-46, 1938. Unfair labor practice strikers, who walk out in protest against unlawful conduct by their employer, may not be permanently replaced and are entitled to reinstatement when they apply for reemployment. Mastro Plastics Corp. v. NLRB, 350 U.S. 270, 278, 1956. 7. Laidlaw Corp. 171 NLRB 1366, 1368, 1968, enforced, 414. F2D 99, 7th CIR 1969, cert. Denied, 397 U.S. 920, 1970. 8. BNA, Daily Labor Report 114, June 13, 1991, A3. 9. Stephen Smith, National Labor Unions v. Multinational Companies. The Dilemma of Unequal Bargaining Power, Columbia. Journal of Transnational Law 11, 1972, 148-53. 10. Hans Gunter, Erosion of Trade Union Power Through Multinational Enterprises. Vanderbilt Journal of Transnational Law 9, 1976, 778. 11. Arthur Shostak, Robust Unionism, Ithaca, NY. ILR Press, 1991, 8-11. 12. NLRB v. International Rice Milling Company, 341 U.S. 665, 672-73, 1951. This aspect of the International Rice Milling decision is now Cody ed. in Section 8, B, 4, B, of the NLRA, 29 U.S.C. Section 158, B, 4, B, 13, Edward J. DiBartolo Corp. v. Florida Gulf Coast Building Trades Council, 485 U.S. 568, 578-88, 1988. 14. Thomas Cocken, Harry Katz and Robert McCursey, The Transformation of American Industrial Relations, New York, Basic Books, 1986, 195-97. 15. See generally. James Pope, Labor Community Coalitions and Boycotts, The Old Labor Law, The New Unionism, and the Living Constitution, Texas Law Review 69, 1991, 889. 16. Ibid. 891-94. 17. Michael Poole, Workers' Participation in Industry, Boston. Routledge and Keegan Paul, 1975, 24-25. 18. John Schmidman, Unions in Postindustrial Society, University Park, PA. Pennsylvania State University Press, 1979, 118. 19. George Strauss, Quality of Work Life and Participation as Bargaining Issues, The Shrinking Perimeter, Hervé Juris and Myron. Roomkin, eds. Lexington, Mass. Lexington Books, 1980, 122. 20. Solomon Barkin, The Decline of the Labor Movement, Santa Barbara, Caliph. Center for the Study of Democratic Institutions, 1961, 17. 21. Michael Poole, Workers' Participation in Industry, 26. 22. OECD, Workers' Participation, Paris, Organization for Economic Cooperation and Development, 1975, 57-58. 23. Clyde Summers, Worker Participation in the U.S. and West Germany. A Comparative Study from an American Perspective. American Journal of Comparative Law 28, 1980, 371, 384. 24. Robert Simison, UAW Struggles with a New Idea. Cooperation. Wall Street Journal, April 14, 1981. Page 30, Call 3, quoting UAW Vice President Donald Eflin. 25. Robert McCormick, Union Representatives as Corporate Directors. The Challenge to the Adversarial Model of Labor Relations, University of Michigan Journal of Law Reform 15, 1982. 222-24. 26. John Dunlop, Past and Future Tendencies of American Labor Organizations, Daedalus, Winter 1978, 84. 27. Peter Drucker, The Unseen Revolution, New York, Harper & Row, 1976, 140. Giles Radis, The Industrial Democrats, Boston. Allen and Unwin, 1978, 124. 28. Daniel Zwerdling, Workplace Democracy, New York, Harper & Row, 1980, 168. 29. Sar Levitan and Cleor Johnson, Labor and Management. The Illusion of Cooperation, Harvard Business Review 61, Sept. October 1983, 3. 30. Daniel Zwerdling, Workplace Democracy, 180. 31. James Furlong, Labor in the Boardroom, Princeton, N.J. Dow Jones Books, 1977, 108-11. 32. Daniel Zwerdling, Workplace Democracy, 171. 33. Ibid. 181. Sar Levitan and Diane Wernick, Worker Participation and Productivity Change, Monthly Labor Review 107, September 1984, 32. 34. B&A, Labor Relations Reporter 127, April 18, 1988, 493. 35. F. Ray Marshall, The Future of the American Labor Movement. The Role of Federal Law, Chicago Kent Law Review 57, 1981, 530. 36. Catherine Stone, Labor and the Corporate Structure. Changing Conceptions and Emerging Possibilities, University of Chicago Law Review 55, 1988, 171. 37. Daniel Zwerdling, Workplace Democracy, 176, quoting researcher Paul Blumberg. 38. B&A, Labor Relations Reporter 119, July 8, 1985, 188-91. Thomas Cocken, Harry Katz and Robert McCursey, The Transformation of American Industrial Relations, New York, Basic Books, 1986, 162-71. 39. Comment, The Saturnization of American Plants. Infringement or Expansion of Workers' Rights? Minnesota Law Review 72, 1987, 173, U.S. Department of Labor, U.S. Labor Law and the Future of Labor Management Cooperation, Bureau of Labor Management Relations Report 104, 1986, 3-6. 40. Daniel Zwerdling, Workplace Democracy, 175, James Furlong, Labor in the Boardroom, 30. 41. Thomas Cocken, Harry Katz and Nancy Mower, Worker Participation in American Unions, Challenges and Choices Facing American Labor, Thomas Cocken, ed. Cambridge, MIT Press, 1985, 277-78. 42. Giles Radis, The Industrial Democrats, 123. 43. Daniel Zwerdling, Workplace Democracy, 2-3. 44. Hem Jane, Worker Participation, New York, Prager, 1980, 324-25. 45. John Schmidman, Unions in Postindustrial Society, 143. 46. Hem Jane, Worker Participation, 3. 47. Ibid. 8. Bennett Abramowitz, Broadening the Board. Labor Participation in Corporate Governance, Southwestern Law. Journal 34, 1980, 981. 48. Note, Alternatives to the United States System of Labor Relations. A comparative analysis of the labor relations systems in the Federal Republic of Germany, Japan, and Sweden, Vanderbilt. Law Review 41, 1988, 644-46. Shinichi Takazawa, The Quality of Working Life. The Japanese Experience, Worker Participation, Hem. Jane, ed. 233. 49. Christopher Byron, An Attractive Japanese Export, Time, March 2, 1981, 74. 50. See generally Hem Jane, Worker Participation. 51. Richard Richardy, Worker Participation in Decisions within Undertakings in the Federal Republic of Germany. Comparative Labor Law 5, 1982, 25. 52. Ibid. 53. Note, Alternatives to the United States System of Labor Relations. A comparative analysis of the labor relations systems in the Federal Republic of Germany, Japan, and Sweden, Vanderbilt. Law Review 41, 1988, 631. 54. Herbert Weidman, Codetermination by workers in German enterprises, American Journal of Comparative Law 28, 1980, 81. 55. Lawrence Zackson, Worker Participation, Industrial Democracy and Managerial Prerogative in the Federal Republic of Germany, Sweden and the United States, Hastings International in Comparative Law Review 8, 1984, 115-16, Manfred Weiss, Labor. Law and Industrial Relations in Europe 1992, a German Perspective, Comparative Labor Law Journal 11, 1990, 418-21. 56. Tom Otterwanger and Ralph Pays, Employee Participation in Corporate Decision-Making. The Dutch Model, International Law 15, 1981, 395-405. 57. Ibid. 400-401. 58. Joseph Meyer, Trade Unions and Worker Participation in Management, The Quality of Working Life, Volume 1, Problems, Prospects and the State of the Art, Lewis Davis, Albert Sherms in Associates, eds. New York, Free Press, 1975, 418-33. 59. Sigvard Rabinowitz, Experiences of Autonomous Working Groups in a Swedish Car Factory, Worker Participation, Hem Jane, ed. 224. 60. William Batt and Edgar Weinberg, Labor Management. Cooperation Today, Harvard Business Review 56, Jan. February 1978. 102. 61. See generally National Center for Productivity and Quality of Working Life, Recent Initiatives in Labor Management Cooperation, Washington, D.C. National Center for Productivity and Quality of Working Life, 1976. 62. Daniel Zwerdling, Workplace Democracy, 19-30. 63. Ibid. 41-51. 64. Ibid. 31-40. 65. BNA, Labor Relations Reporter 110, 1982, 14-16. 66. Hem Jane, Worker Participation, 191, William Batt and Edgar Weinberg, Labor Management Cooperation Today, Harvard Business Review 56, Jan. February 1978, 103. 67. William White, Organizations for the Future, The Next 25 Years of Industrial Relations, Gerald Summers, ed. Madison, Wisconsin, Industrial Relations Research Association, 1973, 132. 68. BNA, Labor Relations Reporter 110, 1982, 15. 69. James Furlong, Labor in the Boardroom, 91, A. H. Raskin, Toward a More Participative Workforce, Working in the 21st Century, Stuart Shepard and Donald Carroll, eds., New York. John Wiley, 1980, 97. 70. Michael Poole, Workers' Participation in Industry, 58. Stephen Doyle, Improving Productivity and Quality of Working Life. The U.S. Experience, Worker Participation, Hem Jane, ed., 255-56. 71. Hem Jane, Worker Participation, 190. 72. Ibid. 34. 73. Daniel Zwerdling, Workplace Democracy, 176-77, William Batt and Edgar Weinberg, Labor Management Cooperation Today. Harvard Business Review 56, Jan. February 1978, 98. 74. John Blackburn, Worker Participation on Corporate Directorates. Is America Ready for Industrial Democracy? Houston. Law Review 18, 1981, 358. 75. James Furlong, Labor in the Boardroom, 29. 76. Comment, An Economic and Legal Analysis of Union Representation on Corporate Boards of Directors, University of Pennsylvania Law Review 130, 1982, 928. 77. Paul Davies, Employee Representation on Company Boards and Participation in Corporate Planning, Modern Law. Review 38, 1975, 254. 78. Ibid. 269. Robert McCormick, Union Representatives as Corporate Directors. The Challenge to the Adversarial Model of Labor Relations, University of Michigan Journal of Law Reform 15, 1982, 226-27, 233. 79. Catherine Stone, The Post-War Paradigm in American Labor Law, Yale Law Journal 90, 1981, 1558. 80. Bennett Abramowitz, Broadening the Board. Labor. Participation in Corporate Governance, Southwestern Law Journal 34, 1980, 982-86. John Blackburn, Worker Participation on Corporate Directorates. Is America Ready for Industrial Democracy? Houston Law Review 18, 1981, 359 to 61. 81. Act on Co-Determination by Jobholders of May 4, 1976, I. BGBL 1153, W. Gear. 82. See generally note, Alternatives to the United States. System of Labor Relations, a comparative analysis of the labor relations systems in the Federal Republic of Germany, Japan, and Sweden. Vanderbilt Law Review 41, 1988, 627. 83. Bennett Abramowitz, Broadening the Board. Labor Participation in Corporate Governance, Southwestern Law Journal 34, 1980, 987 to 90. 84. Robert McCormick, Union Representatives as Corporate Directors. The Challenge to the Adversarial Model of Labor Relations, University of Michigan Journal of Law Reform 15, 1982. 219 n. 4. 85. James Furlong, Labor in the Boardroom, 97. 86. Comment, An Economic and Legal Analysis of Union Representation on Corporate Boards of Directors, University of Pennsylvania Law Review 130, 1982, 940 to 41. 87. Tony Eccles, Control in the Democratized Enterprise, The Case of KME, The Control of Work, John Purcell and Robin Smith, eds. New York, Holmes and Meyer, 1979, 159. 88. Daniel Zwerdling, Workplace Democracy, 172. 89. Robert McCormick, Union Representatives as Corporate Directors. The Challenge to the Adversarial Model of Labor Relations, University of Michigan Journal of Law Reform 15, 1982. 259. 90. Bennett Abramowitz, Broadening the Board. Labor Participation in Corporate Governance, Southwestern Law Journal 34, 1980, 978. 91. 29 U.S.C. Section 158, B, 1, B. 92. Compare NLRB-V. Drivers, chow years, helpers, Local 639, 362 U.S. 274. 1960. Peaceful organizational picketing not coercive under Section 8, B, 1, Edward J. DiBartolo Corp. v. Florida Gulf Coast Building Trades Council, 485 U.S. 568, 1988, and NLRB-V. Fruit and Vegetable Packers and Warehousemen, Local 760, 377 U.S. 58, 1964. Peaceful consumer picketing not coercive under Section 8, B, 4, E, 29 U.S.C. Section 158, B, 4, E. 93. American Broadcasting Cuz. v. Writers Guild of America, West, Inc., 437 U.S. 411, 1978. 94. 29 U.S.C. Section 158, A, 2. 95. 29 U.S.C. Section 152, 5. 96. 29 U.S.C. Section 164, A. 97. NLRB-V. General Steel Erectors, 933 F2D 568, 7th CIR. 1991. Nassau and Sioux Oak Contractors Association, 118 NLRB 174, 187, 1957. 98. Sean Clark, Rethinking the Adversarial Model in Labor Relations. An Argument for Repeal of Section 8, A, 2, Yale Law. Journal 96, 1987, 2023-25, Thomas Kohler, Models of Worker Participation. The Uncertain Signi Cants of Section 8, A, 2, Boston. College Law Review 27, 1986, 518-30, Philip Taft, Organized Labor in American History, New York. Harper and Row, 1964, 452-55. 99. 308 U.S. 241, 1939. 100. 308 U.S. at 251. 101. 360 U.S. 203, 1959. 102. 360 U.S. at 204. 103. 360 U.S. at 211-14. 104. 503 F2D 625, 9th CIR 1974. 105. 503 F2D at 630. 106. 503 F2D at 631. 107. 691 F2D 288, 6th CIR 1982. 108. 691 F2D at 289. 109. 691 F2D at 295. 110. 231 NLRB 1108, 1977. 111. 231 NLRB at 1121. 112. 231 NLRB 1232, 1977. 113. 231 NLRB at 1234. 114. 231 NLRB at 1235. 115. 284 NLRB 621, 1987. 116. 284 NLRB at 622 to 23. 117. 29 USC Section 432, A, 5. 118. BNA, Labor Relations Reporter 106, 1981, 147. 119. IBID, 147 to 48. 120. 29 USC Section 186, B, 1. 121. 29 USC Section 501, A. 122. Section 501, A, also obliges union officers and agents to account to their respective labor organizations for any pro-TS received in connection with transactions conducted on behalf of their respective unions. See generally comment, serving 2. Masters. Union representation on corporate boards of directors. Columbia Law Review 81, 1981, 642 to 44. 123. 29 USC Section 186, C, 3. 124. U.S. Department of Labor, U.S. Labor Law and the Future of Labor Management Cooperation, Bureau of Labor Management. Relations Report 113, 1987, 70-72, quoting letter from George Salem to unidentified ed addressee, dated September 12, 1986. 125. E.g. Bennett Abramowitz, Broadening the Board. Labor. Participation in Corporate Governance, Southwestern Law Journal 34, 1980, 970-75. 126. 15 U.S.C. Section 1. E.g. American Federation of Musicians v. Carroll, 391 U.S. 99, 1968, Amalgamated Meat Cutters and Butcher. Workman v. Jewel Tea Company, 381 U.S. 676, 1965. See generally. Archibald Cox, Labor and the Antitrust Laws, Pennington N. Jewel Tea, Boston University Law Review 46, 1966, 317, Bernard. Meltzer, Labor Unions, Collective Bargaining, and the Antitrust Laws, University of Chicago Law Review 32, 1965, 659. 127. E.g., United Mine Workers v. Pennington, 381 U.S. 657, 1965, Local 626, Meat and Provision Drivers v. United States, 371 U.S. 94, 1962, 128, E.g., H. A. Artists and Associates, Inc. v. Actors Equity Association, 451 U.S. 704, 1981, Amalgamated Meat Cutters and Butcher. Workman v. Jewel Tea Co., 381 U.S. 676, 1965. 129. 15 U.S.C. Section 19. 130. See generally Richard Stoyer, Employee Representation on the Board, Industrial Democracy or Interlocking Directorate. Columbia Journal on Transnational Law 16, 1977, 255. 131. U.S. Department of Labor, U.S. Labor Law and the Future of Labor Management Cooperation, Bureau of Labor Management. Relations Report 104, 1986, 28, quoting letter from Federal Trade Commission to UAW General Counsel John Fillion, dated May 1, 1981. 132. IBID. Quoting letter from Assistant Attorney General Sanford Litvak to UAW General Counsel John Fillion, dated February 26, 1981. 133. Richard Stoyer, Employee Representation on the Board, Industrial Democracy or Interlocking Directorate, Columbia Journal on Transnational Law 16, 1977, 277-79. 134. Comment, An Economic and Legal Analysis of Union Representation of Corporate Boards of Directors, University of Pennsylvania Law Review 130, 1982, 920-22, comment, serving 2 Masters. Union Representation on Corporate Boards of Directors, Columbia Law Review 81, 1981, 652-60. 135. Comment, serving 2 Masters. Union Representation on Corporate Boards of Directors, Columbia Law Review 81, 1981. 652-60. 136. Comment, An Economic and Legal Analysis of Union. Representation on Corporate Boards of Directors, University of Pennsylvania Law Review 130, 1982, 921-22, 948-49. 137, Ibid. 948-49. 138, e.g., Airline Pilots Association v. O'Neill, 111 S. Court 1127, 1991. 139, Ford Motor Company v. Human, 345 U.S. 330, 338, 1953. 140, Comment, An Economic and Legal Analysis of Union. Representation on Corporate Boards of Directors, University of Pennsylvania Law Review 130, 1982, 954. 141, Robert McCormick, Union Representatives as Corporate Directors. The Challenge to the Adversarial Model of Labor Relations, University of Michigan Journal of Law Reform 15, 1982. 247, 252-53. 142, Michael Murphy, Workers on the Board, Borrowing a European Idea, Labor Law Journal 27, 1976, 760-61. 143, NLRB-V, Trute Manufacturing Co., 351 U.S. 149, 1956. 144, John Blackburn, Worker Participation on Corporate Directorates. Is America Ready for Industrial Democracy? Houston Law Review 18, 1981, 366. 145, Giles Radis, The Industrial Democrats, 131. 146, James Furlong, Labor in the Boardroom, 45, 131. 147, Jeremy Rifkin and Randy Barber, The North Will Rise Again, Boston, Beacon Press, 1978, 10-11, W. Michael Kaiser, Labor's New Weapon. Pension Fund Leverage, Can Labor Legally Beat Its Plowshares into Swords? Rutgers Law Review 34, 1982, 409. 148, George Boras, Union Control of Pension Funds, Will the North Rise Again? San Francisco, Institute for Contemporary Studies, 1979, 19-20, W. Michael Kaiser, Labor's New Weapon. Pension Fund Leverage, Can Labor Legally Beat Its Plowshares into Swords? Rutgers Law Review 34, 1982, 409-10, Unions Bid for Bigger Voice in Pension Funds, U.S. News World Report, June 8, 1981, 85. 149, Jeremy Rifkin and Randy Barber, The North Will Rise Again, 81. 150, Ibid, 84. 151, Ibid, 147. 152, Ibid, 149. 153, W. Michael Kaiser, Labor's New Weapon, Pension Fund. Leverage, Can Labor Legally Beat Its Plowshares into Swords? Rutgers Law Review 34, 1982, 412. 154, Jeremy Rifkin and Randy Barber, The North Will Rise Again, 179. 155, BNA, Labor Relations Reporter 109, 1982, 192, BNA. Labor Relations Reporter 109, 1982, 150. 156, BNA, Daily Labor Report 63, April 2, 1991, ALL. By 1991, the union's initial $12 million investment had grown to over $305 million in assets. 157, Jane Zangline, Pensions, Proxies and Power, Recent Developments in the Use of Proxy Voting to Union's Corporate Governance, Labor Lawyer 7, 1991, 77,176. 158, Jeremy Rifkin and Randy Barber, The North Will Rise Again, 150-51. 159, 29 U.S.C. Section 186, c. 5. 160, W. Michael Kaiser, Labor's New Weapon, Pension Fund. Leverage, Can Labor Legally Beat Its Plowshares into Swords? Rutgers Law Review 34, 1982, 415. 161, Pub. L. Number 93-406, 88 Stat. 829, 1974, Cody ed. in various sections of 5, 18, 26, 29, 31 and 42 U.S.C. 162, 29 U.S.C. Section 1104, A. 1. 163, W. Michael Kaiser, Labor's New Weapon, Pension Fund. Leverage, Can Labor Legally Beat Its Plowshares into Swords? Rutgers Law Review 34, 1982, 42,124, 429. 164, Jeremy Rifkin and Randy Barber, The North Will Rise Again, 186. 165. 29 U.S.C. Section 158, E. 166. Michael Gordon, An American Approach to Self-Management, Worker Participation, Hem Jane, ed. 295. 167. Daniel Zwerdling, Workplace Democracy, 95-96, Deborah Olson, Union Experiences with Worker Ownership, Legal and Practical Issues Raised by ESOPs, TRASOPS, Stock Purchases in Cooperatives, Wisconsin Law Review 1982, 769-72. 168. Daniel Zwerdling, Workplace Democracy, 53-63. 169. Ibid, 71-74. 170. Ibid, 66-71. 171. Deborah Olson, Union Experiences with Worker Ownership, Legal and Practical Issues Raised by ESOPs, TRASOPS. Stock Purchases in Cooperatives, Wisconsin Law Review 1982, 753-60. 172. Ibid, 739-42. 173. Ibid, 775-77. 174. Ibid, 778-80. 175. BNA, Daily Labor Report 64, April 3, 1991, A4. 176. BNA, Daily Labor Report, September 26, 1983, A3. 177. Thomas Cocken, Harry Katz and Robert McCursey, The Transformation of American Industrial Relations, New York, Basic Books, 1986, 191-93. 178. Ibid, 193-94. 179. 29 U.S.C. Section 1107, D, 6. 180. 29 U.S.C. Section 1104, A, 1, B. 181. 29 U.S.C. Section 1104, A, 1, C. 182. 29 U.S.C. Section 1104, A, 2. 183. Regarding the legal regulations applicable to the creation and operation of ESOPs, see generally note, Employee Stock Ownership Plans. A Step Toward Democratic Capitalism, Boston. University Law Review 55, 1975, 195, Deborah Olson, Union Experiences with Worker Ownership, Legal and Practical Issues Raised by ESOPs, TRASOPS, Stock Purchases in Cooperatives. Wisconsin Law Review 1982, 732-37. See also Ibid at 733N. 2. For a description of TRASOPs, a type of ESOP created by the Tax Reduction Act of 1975, Pub. L. Number 94-12, Section 301, D, 89 Stat. 26, 1975, 26 U.S.C. Sections 46, 48, and the Tax Reform Act of 1976, Pub. L. Number 94-455, 90 Stat. 1525, 1976. 184. Rich Eld Oil Corp. 110 NLRB 356, 1954, enforced, 231. F2D 717, DC. CIR. Cert. Denied, 351 U.S. 909, 1956. 185. Brookings Plywood Corp. 98 NLRB 794, 798, 1952. 186. Coastal Plywood, 102 NLRB 300, 1953, Mutual Rough Hat Company, 86 NLRB 440, 1949, Muskogee Dairy Products Company, 85. NLRB 520, 1949. 187. 29 U.S.C. Section 158, A, 2. 188. 29 U.S.C. Section 152, 5. 189. Note, Worker Ownership in Section 8, A, 2, of the National Labor Relations Act, Yale Law Journal 91, 1982, 615. 190. 29 U.S.C. Section 501, A. 191. Deborah Olson, Union Experiences with Worker Ownership, Legal and Practical Issues Raised by ESOPs, TRASOPs. Stock Purchases in Cooperatives, Wisconsin Law Review 1982, 801-2. If representative labor organizations and worker-owned enterprises act in good faith to further the legitimate interests of the employees and do not enter into collective bargaining arrangements designed to restrain trade, their cooperative conduct should be exempt from antitrust liability. IBID 803-8. 192. Daniel Zwerdling, Workplace Democracy, 100. 193. IBID 101. 194. Richard Long, The EECTS of Employee Ownership on Organizational Identication, Employee Job Attitudes, and Organizational Performance, a Tentative Framework and Empirical Findings, Human Relations 31, 1978, 39-40. 195. IBID 47. Michael Conte and Arnold Tannenbaum, Employee-Owned Companies, Is the D-Errance Measurable? Monthly Labor Review 101, July 1978, 25-26. 196. James O'Toole, The Uneven Record of Employee Ownership, Harvard Business Review 57, November-December 1979, 194. 197. Michael Conte and Arnold Tannenbaum, Employee-Owned Companies, Is the D-Errance Measurable? Monthly Labor Review 101, July 1978, 24. 198. Daniel Zwerdling, Workplace Democracy, 167-68, quoting William Burns, Assistant Research Director for the Amalgamated Meat Cutters, 199. IBID 98. 200. Deborah Olson, Union Experiences with Worker Ownership, Legal and Practical Issues Raised by ESOPs, TRASOPS. Stock Purchases and Cooperatives, Wisconsin Law Review 1982, 753. 201. Daniel Zwerdling, Workplace Democracy, 103. 202. Deborah Olson, Union Experiences with Worker Ownership, Legal and Practical Issues Raised by ESOPs, TRASOPS. Stock Purchases and Cooperatives, Wisconsin Law Review 1982, 744-46. 203. Peter Drucker, The Unseen Revolution, 146-47. 204. James O'Toole, The Uneven Record of Employee Ownership, Harvard Business Review 57, November-December 1979, 193. 205. Roger McElrath and Richard Rowan, The American Labor Movement and Employee Ownership, Objections to and Uses of Employee Stock Ownership Plans, Journal of Labor Research 13, Winter 1992, 106. 206. 42 U.S.C. Section 2000E et seq. 207. 42 U.S.C. Section 1981, which guarantees all persons the same right to make and enforce contracts, including contracts of employment, as is enjoyed by white citizens. 208. Ward's Cove Packing Company v. Antonio, 490 U.S. 642, 1989. 209. Patterson v. McLean Credit Union, 491 U.S. 164, 1989. Fortunately for the victims of employment discrimination, organized labor and other groups were able to induce Congress to statutorily reverse this conservative group of Supreme Court decisions through the enactment of the Civil Rights Act of 1991. Pub. Law No. 102-166, 105 Stat. 1071, 1991. 210. Thomas Cochin and Kirsten Weaver, American Unions and the Future of Worker Representation, The State of the Unions, George Strauss, Daniel Gallagher and Jack Fiorito, eds. Madison. Wyss. Industrial Relations Research Association, 1991, 381. 211. BNA, Daily Labor Report 26, February 7, 1991, B9. 212. John Delaney and Merrick Masters, Unions and Political Action, The State of the Unions, George Strauss, Daniel Gallagher and Jack Fiorito, eds. Madison, Wisconsin, Industrial Relations Research Association, 1991, 318. 213. John Delaney, The Future of Unions as Political Organizations, Journal of Labor Research 12, Fall 1991, 374. 214. Thomas Edsel, The New Politics of Inequality, New York. W. W. Norton, 1984, 167. 215. James Bennett, Private Sector Unions, The Myth of Decline, Journal of Labor Research 12, Winter 1991, 6. 216. IBID 7. 217. IBID 3. 218. IBID 219. Lloyd Ullman, Multinational Unionism, Incentives, Barriers and Alternatives, Industrial Relations 14, 1975, 4-5. 220. International Labor OCE, Employment EECTS of Multinational Enterprises in Industrial Countries, Geneva, International Labor OCE, 1981, 17. 221. Stanley Ruttenberg, The Union View of Multinationals. An Interpretation, Bargaining Without Boundaries, Robert. Flanagan and Arnold Weber, eds. Chicago, University of Chicago. Press. 1974, 181-84. 222. BNA, Daily Labor Report, December 16, 1982, A4. 223. Herbert Northrop and Richard Rowan, Multinational. Collective Bargaining Attempts, Philadelphia, Industrial Research. Unit, Wharton School, University of Pennsylvania, 1979, 540. 224. International Labor OCE, Multinational Enterprises in Social Policy, Geneva. International Labor OCE, 1973, 95. 225. IBID. 67, quoting Walter Reuther, Worldwide Labor. Solidarity, essential for developing international cooperation. International Metalworkers Federation Bulletin, November 1964, 12. 226. William Curtin, The Multinational Corporation in Transnational Collective Bargaining, American Labor and the Multinational Corporation, Dwayne Kujawa, ed. New York. Prager, 1973, 212. 227. Jerome Rousseau, International Relations and the Multinational Corporation, The Management Approach, Bargaining Without Boundaries, Robert Flanagan and Arnold Weber, eds. 15253. 228. Herbert Northrop and Richard Rowan, Multinational. Collective Bargaining Attempts, 544. 229. Richard Barnett and Ronald Muller, Global Reach, The Power of the Multinational Corporations, New York. Simon & Schuster, 1974, 314-18. 230. Charles Levinson, International Trade Unionism, London. Allen and Unwin, 1972, 115. 231. Hugh Stevenson, The Coming Clash, New York. Saturday. Review Press, 1972, 161-65. Lewis Turner, Invisible Empires. Multinational Companies in the Modern World, New York. Harcourt. Brace Jovanovich, 1970, 98-102. 232. Herbert Northrop, Why Multinational Bargaining Neither Exists Nor is Desirable, Labor Law Journal 29, 1978, 330. 233. Lloyd Ullman, Multinational Unionism, Incentives, Barriers and Alternatives, Industrial Relations 14, 1975, 1. 234. William Curtin, The Multinational Corporation in Transnational Collective Bargaining, in American Labor and the Multinational Corporation, Dwayne Kujawa, ed. 203. 235. IBID. 205-6, G. B. J. Bomers, Multinational Corporations and Industrial Relations, Assen, Netherlands. Van Gorkum, 1976, 27. 236. Benjamin Aaron, Labor Relations in the United States. From a Comparative Perspective, Washington and Lee Law Review 39, 1982, 1252-53. 237. David Blake, International Labor and the Regulation of Multinational Corporations, Proposals and Prospects, San Diego. Law Review 11, 1973, 184-85. 238. Robert Cox, Labor and Transnational Relations. International Organization 25, 1971, 568. 239. IBID. 560. 240. International Labor OCE, Multinational Enterprises in Social Policy, 68. 241. John Windmuller, International Trade Union. Organizations. Structure, Functions, Limitations, International. Labor. Solomon Barkin, ed. New York. Harper and Row, 1967, 8287. 242. Charles Levinson, International Trade Unionism, 132-33. 243. G. B. J. Bomers, Multinational Corporations and Industrial Relations, 34-36. 244. Roger Blanpain, 1992 and Beyond. The Impact of the European Community on the Labor Law Systems of the Member Countries, Comparative Labor Law Journal 11, 1990, 409. 245. Tiziano True, European Uni-Cation and Italian Labor Relations, Comparative Labor Law Journal 11, 1990, 450-53. 246. BNA, Labor Relations Reporter 127, February 1, 1988, 147. 247. Robert Cox, Labor and the Multinationals, Foreign Affairs 54, January 1976, 362. 248. David Blake, International Labor and the Regulation of Multinational Corporations, Proposals and Prospects, San Diego. Law Review 11, 1973, 190. 249. Frank Tannenbaum, The Survival of the Fittest. Columbia Journal of World Business 3, Mar. April 1968, 18-19. 250. Robert Cox, Labor and the Multinationals, Foreign. Airs 54, January 1976, 360. 251. B&A, Daily Labor Report, January 27, 1983, A5, B&A. Daily Labor Report, June 21, 1983, AL, D1. 252. B&A, Daily Labor Report 242, December 17, 1990, A5. See generally note, the Vredling Directive, the EEC's failed attempt to regulate multinational enterprises and organize collective bargaining, Journal of International Law and Politics 20, 1988. 967. 253. B&A, Daily Labor Report 123, June 26, 1991, A5. See generally George Craw, The Community Charter of the Fundamental Social Rights of Workers, Hastings International and Comparative Law Review 13, 1990, 467, Donald Dowling, Worker. Rights in the Post-1992 European Communities. What social Europe means to United States-based multinational employers. Northwestern Journal of International Law and Business 11, 1991. 564. 6. The need to reform. 1. E.g., Commonwealth v. Pullis, 3 Doc. Hist. of Am. Ind. Society 59, 2d ed. Commons 1910. Philadelphia Mayor's Court 1806. See generally William Forbath, The Shaping of the American Labor Movement. Harvard Law Review 102, 1989, 1148-53. 2. Felix Frankfurter and Nathan Green, The Labor Injunction, New York. Macmillan, 1930. 3. Philip Taft, Organized Labor in American History, New York. Harper and Row, 1964, 136-58. 4. E.g., Adair v. United States, 208 U.S. 161, 1908, Yellow Dog Contracts, in Ray Jacobs, 98 NY 98, 1885. Voiding New York law precluding production of cigars in tenement dwellings. 5. 38 Stat. 730, 1914. 6. Duplex Printing Press Company v. Deering, 254 U.S. 443, 1921. 7. 47 Stat. 70, 1932. 8. 48 Stat. 198, 1933. 9. Schechter Poultry Corp. v. United States, 295 U.S. 495, 1935. 10. 49 Stat. 449, 1935. 11. 49 Stat. 449, 1935. The NLRA, as amended by the Labor Management Relations Act, Pub. L. Number 101, 61 Stat. 136, 1947, and the Labor Management Reporting and Disclosure Act, Pub. L. Number 257, 73 Stat. 519, 1959, is set forth in 29 U.S.C. Sections 151-69. 12. Ibid. 13. Ibid. 14. NLRB-V. Jones and Laughlin Steel Corp. 301 U.S. 1, 33, 1937. 15. NLRB. NLRB. The First 50 Years, Washington, D.C. National Labor Relations Board, 1985, v. 16. Ibid. 17. Section 8, D. 29 U.S.C. Section 158, D. 18. 322 U.S. 111, 1944. 19. 330 U.S. 485, 1947. 20. 322 U.S. at 127-28. 21. Robert Gorman, Labor Law. Basic Text, Street. Paul. West. Publishing, 1976, 197-98. 22. E.g., Daltex Optical Company, 137 NLRB 1782, 1962. 23. 140 NLRB 221, 1962. 24. NLRB-V. Exchange Parts Company, 375 U.S. 405, 1964. 25. NLRBV. Burnup and Sims, Inc., 379 U.S. 21, 1964. 26. E.g., Joy Silk Mills, Inc., 85 NLRB 1263, 1949, enforced, 185 F2D 732, D.C. CIR 1950, Snow and Sons, 134 NLRB 709, 1961, enforced, 308 F2D 687, 9th CIR 1962. 27. NLRBV. Gissel Packing Company, 395 U.S. 575, 613-14, 1969. 28. E.g., Conair Corp., 261 NLRB 1189, 1982. The D.C. Circuit Court refused to enforce this portion of the board's remedial order, since it concluded that any departure from the principle of majority rule should be left to Congress. Conair Corp. v. NLRB 721. F2D 1355, D.C. CIR 1983, Cert. Denied, 467 U.S. 1241, 1984. 29. INT. Ladies Garment Workers Union v. NLRB 366 U.S. 731, 1961. Voluntary extension of representation status to minority union per se unfair labor practice regardless of good or bad faith of employer and labor organization. 30. Interbureau Contractors, 157 NLRB 1295, 1966, enforced, 388 F2D 495, 2D CIR 1967. This doctrine was sustained by the Supreme Court in NLRB v. City Disposal Systems, 465 U.S. 822, 1984. 31. 221 NLRB 999, 1975. 32. 420 U.S. 251, 1975. 33. 262 NLRB 1010, 1982. 34. E.g., Kohler Company, 148 NLRB 1434, 1964, ARMED, 345. F2D 748, D.C. CIR, Cert. Denied, 382 U.S. 836, 1965. 35. 29 U.S.C. Section 158, D. 36. Phelps Dodge Copper Corp. 101 NLRB 360, 1952. 37. Inland Steel Company v. NLRB 170 F2D 247, 7th CIR 1948, Cert. Denied, 336 U.S. 960, 1949. 38. W. Cross and Company v. NLRB 174 F2D 875, 1st CIR 1949. 39. Singer MFGR. Company, 24 NLRB 444, 1940, enforced, 119. F2D 131, 7th CIR, Cert. Denied, 313 U.S. 595, 1941. 40. Central Illinois Public Service Company, 139 NLRB 1407, 1962, enforced, 324 F2D 916, 7th CIR 1963. 41. NLRBV. Gulf Power Company, 384 F2D 822, 5th CIR 1967. 42. Beacon Piece Dyeing and Finishing Company, 121 NLRB 953, 1958. 43. NLRBV. Boss MFGR. Company, 118 F2D 187, 7th CIR 1941. 44. United States Gypsum Company, 94 NLRB 112, amended, 97. NLRB 889, 1951, Modi ed on other grounds, 206 F2D 410, 5th. CIR 1953, Cert. Denied, 347 U.S. 912, 1954. 45. Fiberboard Paper Products Corp. v. NLRB 379 U.S. 203, 1964. 46. Comment. Subjects included within management's duty to bargain collectively. Louisiana Law Review 26, 1966, 634. 47. 388 U.S. 175, 1967. 48. 29 U.S.C. Section 158, B, 1, A. 49. 388 U.S. at 181. 50. 412 U.S. 67, 1973. 51. Union of Electrical Workers, Local 1012, 187 NLRB 375, 1970. 52. 351 U.S. 225, 1956. 53. 367 U.S. 740, 1960. 54. 304 U.S. 333, 1938. 55. 304 U.S. at 345 to 46. 56. NLRBV. International Van Lines, 409 U.S. 48, 1972. 57. Laidlaw Corp. 171 NLRB 1366, 1968, enforced, 414 F2D 99. 7th CIR 1969, cert. Denied, 397 U.S. 920, 1970. 58. 29 U.S.C. Section 159, C. 3. 59. NLRBV. Erie Resistor Corp. 373 U.S. 221, 1963. 60. 675 F2D 926, 7th CIR 1982. 61. The Giddings and Lewis approach continues to be followed today. Aqua Chem, Inc. v. NLRB, 910 F2D 1487, 7th CIR 1990, rehearing denied, 922 F2D 403, 7th CIR, cert. Denied, 111 S. Court, 2871, 1991, 62, 489 U.S. 426, 1989. 63, Pub. L. Number 101, 61 Stat. 140, 1947. 64, 29 U.S.C. Section 160, 1. 65, Section 303 of the LMRA, 29 U.S.C. Section 187. 66, Pub. L. Number 86 to 257, 73 Stat. 525, 542, 1959. 67, Section 8, E. of the NLRA, 29 U.S.C. Section 158, E. 68, 29 U.S.C. Section 158, B. 7. 69, 61 Stat. 137, 1947, Cody ed. at 29 U.S.C. Section 152, 3. 70, 404 U.S. 157, 1971. 71, NLRBV. Yeshiva University, 444 U.S. 672, 1980. 72, NLRBV. Bell Aerospace Company, 416 U.S. 267, 288, 1974. 73, 265 NLRB 295, 1982. 74, 140 NLRB 221, 1962. 75, Julius Getman, Stephen Goldberg and Gene Herman, Union. Representation Elections. Law and Reality, New York, Russell Sage. Foundation, 1976. 76, 228 NLRB 1311, 1977. 77, 228 NLRB at 1313. In General Nit of California, Inc., 239 NLRB 619, 1978. A new 3-2 board majority overruled shopping cart and reinstated the Hollywood ceramics test, but 4 years later, another 3-2 majority overruled General Nit and returned to the sound rule that had been enunciated in shopping cart. Midland Natal Life Insurance Company, 263 NLRB 127, 1982. 78, E.G., Fiber Lam, Inc., 301 NLRB. Number 9, 136 LRRM. 1147, 1991, TriCast, Inc., 274 NLRB 377, 1985. 79, Gourmet Foods, Inc., 270 NLRB 578, 1984. 80, 268 NLRB 493, 1984. 81, Sears, Roebuck and Company, 274 NLRB 230, 1985. 82, 268 NLRB 1044, 1984, ARMED, 765 F2D 148, 9th CIR. 1985, 83, 452 U.S. 666, 1981. 84. 452 U.S. at 678 to 79. 85. 303 NLRB. Number 66, 137 LRRM 1185, 1991. 86. 409 U.S. 213, 1972. 87. 473 U.S. 95, 1985. 88. 29 U.S.C. Section 158, B, 1, A. 89. 466 U.S. 435, 1984. 90. 111 S. Court 1950, 1991. Even though the Leonard case involved a public sector union, the parameters set forth in that decision will undoubtedly be applied to private sector labor organizations. 91. BNA, Daily Labor Report 72, April 14, 1992, D1. 92. BNA, Daily Labor Report 73, April 15, 1992, A9, D1. 93. 29 U.S.C. Section 152, 3. 94. E.g., Yamada Transfer, 115 NLRB 1330, 1956, American. Cable and Radio Corp. 121 NLRB 258, 1958. 95. C. Wright Mills, White Collar, New York, Oxford University. Press. 1951, 86 to 89. 96. Marion Crane, Building Solidarity Through Expansion of NLRA Coverage, A Blueprint for Worker Empowerment, Minnesota. Law Review 74, 1990, 1006 to 8. 97. Compare NLRB-V. Hendricks County Rural Electric, Membership Corp. 454 U.S. 170, 1981, wherein the Supreme Court limited the labor board's confidential employee exclusion to those individuals who actually have access to confidential labor relations information. The court refused to permit the exclusion to be applied to individuals who have access to other forms of confidential company information. 98. NLRB-V. Gissel Packing Company, 395 U.S. 575, 618 to 19, 1969. 99. 263 NLRB 127, 1982. 100. 140 NLRB 221, 1962. 101. NLRB-V. United Steelworkers, 357 U.S. 357, 1958. 102. Carl Clare, Workplace Democracy and Market Reconstruction. An Agenda for Legal Reform, Catholic University. Law Review 38, 1988, 45 to 51. 103. Excelsior Underwear, Inc., 156 NLRB 1236, 1966. 104. 304 U.S. 333, 1938. 105. Daniel Pollitt, McKay Radio, Turn It O, Tune It Out. University of San Francisco Law Review 25, 1991, 296 to 97. 106. BNA, Daily Labor Report 114, June 13, 1991, A3. 107. Clyde Summers, Past Premises, Present Failures, and Future Needs in Labor Legislation, BU Allo Law Review 31, 1982. 10. 108. Matthew Finken, Labor Policy and the Innervation of the Economic Strike, University of Illinois Law Review 1990 to 569-70. 109. C. E.g., NLRB-V. Great Dane Trailers, Inc., 388 U.S. 26, 1967. C. Generally Thomas Christensen and Andrea Svano, Motive and Intent in the Commission of Unfair Labor Practices. Yale Law Journal 77, 1968, 1269. Walter Oberer, The Scienter. Factor in Sections 8, A, 1, and 3 of the Labor Act, of Balancing. Hostile Motive, Dogs and Tails, Cornell Law Quarterly 52, 1967. 491. 110. Daniel Pollitt, McKay Radio, Turn It O, Tune It Out. University of San Francisco Law Review 25, 1991, 306 to 7. 111. BNA, Daily Labor Report 138, July 18, 1991, A11. 112. 29 U.S.C. Section 158, B, 4, B. 113. NLRB-V. Fruit and Vegetable Packers and Warehousemen. Local 760, 377 U.S. 58, 1964. 114. NLRB-V. Retail Store Employees Union, Local 1001, 447 U.S. 607, 1980, 115, Edward DeBartolo Corp. v. Florida Gulf Coast Building and Construction Trades Council, 485 U.S. 568, 1988, 116, 29 U.S.C. Section 158, E. 117, Charles Craver, Public Sector Impasse Resolution. Procedures, Chicago-Kent Law Review 60, 1984, 783-85. 118, C. Generally George Goebel, The Non-Stoppage Strike. Labor Law Journal 2, 1951, 105, Howard Marshall and Natalie Marshall, Non-Stoppage Strike Proposals, A Critique, Labor Law. Journal 7, 1956, 299. David McCalmont, The Semi-Strike. Industrial and Labor Relations Review 15, 1962, 191. 119. Myers Industries, 268 NLRB 493, 1984. 120. See generally Richard Fiscal, Self, Others, and Section 7. Mutualism and Protected Protest Activities under the National Labor Relations Act, Columbia Law Review 89, 1989, 789, Charles Morris, NLRB Protection in the Non-Union Workplace. A Glimpse at a General Theory of Section 7 Conduct, University of Pennsylvania. Law Review 137, 1989, 1673. 121. 274 NLRB 230, 1985. 122. Catherine Stone, The Post-War Paradigm in American Labor Law, Yale Law Journal 90, 1981, 1558. 123. 29 U.S.C. Section 8, D. 124. Catherine Stone, Labor and the Corporate Structure. Changing Conceptions and Emerging Possibilities, University of Chicago Law Review 55, 1988, 86-87. 125. NLRB-V. Katz, 369 U.S. 736, 1962. 126. 29 U.S.C. Section 158, B, 1, A. 127. 29 U.S.C. Section 160, 1. 128. Terminal Freight Handling Company v. Solian, 444 F2D 699, 8th. CIR 1971, Cert. Denied, 405 U.S. 996, 1972. 129. 29 U.S.C. Section 187. 130. 29 U.S.C. Section 160, J. 131. Paul Weiler, Governing the Workplace, Cambridge. Harvard University Press, 1990, 238-39. 132. Clear Pine Moldings, 268 NLRB 1044, 1984, ARMED, 765 F2D 148, 9th CIR 1985. 133. Gourmet Foods, Inc., 270 NLRB 578, 1984. 134. Phelps Dodge Corp. v. NLRB, 313 U.S. 177, 1941. 135. Paul Weiler, Promises to Keep, Securing Workers' Rights to Self-Organization under the NLRA, Harvard Law Review 96, 1983, 1792. 136. Ibid. 1795 and N. 94. 137. See generally Benjamin Wilkinson, The Remedial Efficacy of NLRB Remedies in Joysilk Cases, Cornell Law Review 55, 1969, 1. 138. Once such labor board bargaining orders are judicially enforced, continued contumacy by employers would subject them to contempt liability. 139. 29 U.S.C. Section 216, B. 140. See generally note, non-majority bargaining orders, the only effective remedy for pervasive employer unfair labor practices during union organizing campaigns, Journal of Law. Reform 20, 1987, 617. 141. Ex-Cell O Corp. 185 NLRB 107, 1970, ARMED, 449. F2D 1058, DC. CIR 1971. 142. 29 U.S.C. Section 160, C. Empowers the Labor Board to issue remedial orders that will effectuate the policies of the NLRA. 143. 29 U.S.C. Section 160, A. 144. 112 NLRB 1080, 1955. 145. 112 NLRB at 1082. 146. 268 NLRB 573, 1984. 147. 268 NLRB at 574. 148. United Steelworkers v. Enterprise Wheel and Car Corp. 363. US 593, 1960. 149. Universal Camera Corp. v. NLRB. 340 US 474, 1951. 150. Section 203, d, of the LMRA, 29 U.S.C. Section 173, d, provides that final adjustment by a method agreed upon by the parties is declared to be the desirable method for settlement of grievance disputes arising over the application or interpretation of an existing collective bargaining agreement. 151. 192 NLRB 837, 1971. 152. 228 NLRB 808, 1977. Bibliography. Aaron, Benjamin, Labor Relations in the United States from a Comparative Perspective, Washington and Lee Law Review 39, 1982, 1247. Abramowitz, Bennett, Broadening the Board. Labor Participation in Corporate Governance, Southwestern Law Journal 34, 1980. 963. AFL-CIO Committee on the Evolution of Work, The Changing Situation of Workers and Their Unions. Washington, D.C. AFL-CIO, 1985. Amoroso, Bruno, A Danish Perspective, The Impact of the Internal Market on the Labor Unions and the Welfare State. Comparative Labor Law Journal 11, 1990, 483. Angel, Marina, Professionals in Unionization, Minnesota Law. Review 66, 1982, 383. Aronowitz, Stanley, False Promises. New York. McGraw-Hill, 1973. Askin, Steve, Turmoil in the Ranks, Black Enterprise, September 1982. 59. Atlison, James, Re-Actions on Labor, Power and Society, Maryland. Law Review 44, 1985, 841. Atlison, James, Values and Assumptions in American Labor Law. Amherst, Mass. University of Massachusetts Press, 1983. Axelrod, Jonathan, Common Obstacles to Organizing Under the NLRA, Combating the Southern Strategy, North Carolina Law. Review 59, 1980, 147. Bailser, Diane, Sisterhood and Solidarity. Boston. South End Press, 1987. Barkin, Solomon, The Decline of the Labor Movement. Santa Barbara, Caliph. Center for the Study of Democratic Institutions, 1961. Barkin, Solomon, International Labor. New York. Harper and Row, 1967. Barkin, Solomon, A New Agenda for Labor, Fortune, November 1960. 250. Barnett, Richard, A Reporter at Large, New Yorker, April 7, 1980. 46. Barnett, Richard and Ronald Muller, Global Reach, The Power of the Multinational Corporations. New York. Simon & Schuster, 1974. Barnett, George, American Trade Unionism and Social Insurance. American Economic Review 23, March 1933, 1. Bartosich, Florian and Roger Hartley, Labor Relations Law in the Private Sector. Philadelphia. American Law Institute, 1986. Batt, William and Edgar Weinberg, Labor Management Cooperation. Today, Harvard Business Review 56, Jan. February 1978, 96. Beale, Calvin, Renewed Growth in Rural Communities, Futurist 9, August 1975, 196. Beckwith, Burnham, The Next 500 Years. New York. Exposition Press, 1967. Bennett, James, Private Sector Unions, The Myth of Decline. Journal of Labor Research 12, Winter 1991, 1. Bernstein, Jules, Union Busting, From Benign Neglect to Malignant Growth, University of California, Davis Law Review 14, 1980, 1. Best, Fred, Recycling People, Work Sharing Through Flexible Life. Scheduling, Futurist 12, February 1978, 13. Bibb, Robert, Blue-Collar Women in Low-Wage Industries, A Dual Labor Market Interpretation, The American Working Class, Irving Horowitz, John Leggett and Martin Oppenheimer, eds. New Brunswick, N.J. Transaction Books, 1979-125. Blackburn, John, Worker Participation on Corporate Directorates. Is America Ready for Industrial Democracy? Houston Law? Review 18, 1981, 349. Blake, David, International Labor and the Regulation of Multinational Corporations, Proposals and Prospects, San Diego. Law Review 11, 1973, 179. Blanche Ower, David and Richard Freeman, Going the Errant Ways. Unionism in the U.S. and Other Advanced OECD Countries. Cambridge, Massachusetts. National Bureau of Economic Research. Working Paper 3342, April 1990. Blancpain, Roger, 1992 and Beyond. The Impact of the European Community on the Labor Law Systems of the Member Countries. Comparative Labor Law Journal 11, 1990, 403. Bloom, Albert, A History of the American Labor Movement. Washington, D.C. American Historical Association, 1972. Bach, Derek and John Dunlop, Labor and the American Community. New York. Simon & Schuster, 1970. Bomers, G. B. J. Multinational Corporations and Industrial Relations. Assen, Netherlands. Van Gorkum, 1976. Bonacic, Edna, A Theory of Ethnic Antagonism, The Split Labor Market, The American Working Class, Irving Horowitz, John. Leggett and Martin Oppenheimer, eds. New Brunswick, N.J. Transaction Books, 1979-73. Boras, George, Union Control of Pension Funds, Will the North Rise Again? San Francisco. Institute for Contemporary Studies, 1979. Bureau of National Heirs, The Employment at Will Issue. Washington, D.C. Bureau of National Heirs, 1982. Bureau of National Heirs, Older Americans in the Workforce. Challenges and Solutions. Washington, D.C. Bureau of National Heirs, 1987. Bureau of National Heirs, Unions Today, New Tactics to Tackle Tough Times. Washington, D.C. Bureau of National Heirs, 1985. Byron, Christopher, An Attractive Japanese Export, Time, March 2, 1981, 74. Carnevale, Anthony and Harold Goldstein, Schooling and Training for Work in America, An Overview, New Developments in Worker Training. A Legacy for the 1990s, Louis Furman, Michelle Hoyman, Joel Kutcher Gershenfeld and Ernest Savoy, eds. Madison, Wisconsin. Industrial Relations Research Association, 1990. 30. Chason, Gary and Joseph Rose, The Macrodeterminants of Union Growth and Decline, The State of the Unions, George Strauss. Daniel Gallagher and Jack Fiorito, eds. Madison, Wisconsin, Industrial Relations Research Association, 1991-3. Christensen, Thomas and Andrea Svano, Motive and Intent in the Commission of Unfair Labor Practices, Yale Law Journal 77, 1968, 1269. Clark, Sean, Rethinking the Adversarial Model in Labor Relations. An Argument for Repeal of Section 8, A. 2, Yale Law Journal 96, 1987, 2021. Coates, Joseph, Jennifer Jarrett and John Mahai, Future Work. The Futurist 25, May to June 1991, 9. Cohen, Sanford, Labor in the United States. Columbus, Ohio. Merrill, Publishing, 5th ed., 1979. Killingsworth, Terrence, American Labor Policy in the International Economy. Clarifying Policies and Interests, Boston. College Law Review 31, 1989, 31. Commission on Workforce Quality and Labor Market East Shensi. Investing in People. Washington, D.C., U.S. Department of Labor, 1989. Comment, An Economic and Legal Analysis of Union Representation of Corporate Boards of Directors, University of Pennsylvania Law Review 130, 1982, 919. Comment, The Saturnization of American Plants, Infringement or Expansion of Workers' Rights, Minnesota Law Review 72, 1987, 173. Comment, Serving Two Masters, Union Representation on Corporate Boards of Directors, Columbia Law Review 81, 1981. 639. Comment, Subjects included within management's duty to bargain collectively, Louisiana Law Review 26, 1966, 630. Commons, John and Associates, History of Labor in the United States. New York, Macmillan, 1918. Conte, Michael and Arnold Tannenbaum, Employee-Owned Companies. Is the D-Errance Measurable? Monthly Labor Review 101, July 1978, 23. Cooper, Lyle, The American Labor Movement in Prosperity and Depression. American Economic Review 22, December 1932, 641. Cox, Archibald, The Duty to Bargain in Good Faith, Harvard Law Review 71, 1958, 1401. Cox, Archibald, Labor and the Antitrust Laws, Pennington N. Jewell T., Boston University Law Review 46, 1966, 317. Cox, Robert, Labor and the Multinationals, Foreign Heirs 54, January 1976, 344. Cox, Robert, Labor and Transnational Relations, International. Organization 25, 1971, 554. Crane, Marion, Building Solidarity Through Expansion of NLRA. Coverage. A Blueprint for Worker Empowerment, Minnesota. Law Review 74, 1990, 953. Crane, Marion, Feminism, Labor, and Power, Southern California. Law Review 65, 1992, 1819. Crane, Marion, Feminizing Unions, Challenging the Gendered Structure of Wage Labor, Michigan Law Review 89, 1991. 1155. Craver, Charles, The Application of the Age Discrimination in Employment Act to Persons Over 70, George Washington. Law Review 58, 1989, 52. Craver, Charles, The Impact of Financial Crises Upon Collective Bargaining Relationships, George Washington Law Review 56, 1988, 465. Craver, Charles, The Inquisitorial Process in Private Employment. Cornell Law Review 63, 1977, 1. Craver, Charles, Public Sector Impasse Resolution Procedures. Chicago-Kent Law Review 60, 1984, 779. Craver, Charles, The Vitality of the American Labor Movement in the 21st Century, University of Illinois Law Review 1983, 633. Kerm, Michael, Barry Hirsch and David McPherson, Union. Membership and Contract Coverage in the United States, 19,831,988, Industrial and Labor Relations Review 44, October 1995. Curtin, William, The Multinational Corporation and Transnational Collective Bargaining, American Labor and the Multinational Corporation, Dwayne Kujawa, ed. New York. Prager, 1973-192. Davies, Paul, Employee Representation on Company Boards in Participation in Corporate Planning, Modern Law Review 38, 1975, 254. Delaney, John, The Future of Unions as Political Organizations. Journal of Labor Research 12, Fall 1991, 373. Delaney, John and Merrick Masters, Unions and Political Action, The State of the Unions, George Strauss, Daniel Gallagher and Jack Fiorito, eds. Madison, Wisconsin, Industrial Relations Research Association, 1991-313. DeMott, Benjamin, The Imperial Middle. New York. William Morrow and Company, 1990. Dolan, Brendan, McKay Radio. If it isn't broken, don't fix it. University of San Francisco Law Review 25, 1991, 313. Dowling, Donald, Worker Rights in the Post-1992 European Communities. What Social Europe Means to United States-Based Multinational Employers, Northwestern Journal of International Law and Business 11, 1991, 564. Doyle, Stephen, Improving Productivity and Quality of Working Life. The U.S. Experience, Worker Participation, Hem Jane, ed. New York. Prager, 1980-249. Drucker, Peter, The Unseen Revolution. New York. Harper and Row, 1976. Dulles, Foster and Melvin Dubofsky, Labor in America. Arlington Heights, 3. Harlan-Davidson, 1984. Dunlop, John, Past and Future Tendencies of American Labor Organizations. Daedalus, Winter 1978, 84. Eccles, Tony, Control in the Democratized Enterprise, The Case of KME, The Control of Work, John Purcell and Robin Smith, eds. New York. Holmes and Meyer, 1979-156. Edsel, Thomas, The New Politics of Inequality. New York. W. W. Norton, 1984. Edwards, Harry, R. Theodore Clark and Charles Craver, Labor Relations Law in the Public Sector. Charlottesville, VA. Michie. Company, 4th ed. 1991. Ehrenreich, Barbara, Fear of Falling. New York. Harper Perennial, 1990. Ehrenreich, Barbara, The Worst Years of Our Lives. New York. Pantheon Books, 1990. El-Khoury, Frank and Edna El-Khoury, How Arbitration Works. Washington, D.C. Bureau of National Heirs, 1985. Furman, Lewis, Michelle Hoyman and Joel Kutcher-Gershenfeld, Joint Union Management Training Programs, a synthesis in the evolution of jointism and training.